I don't know.
701 and 701.1, Mr. Venu is an AOR. I have received instructions from him. Firstly, he is indisposed, can't walk, being 87-year-old. And
what we'll do is in all these matters,
yes,
the idea is to get these matters ready for hearing.
Yes.
So we'll pass a common order in all these matters in terms of the circular of the 22nd of August 2023, that the compilation of documents, the compilation of pleadings, documents, and precedent, that must be all filed within, say, we'll give 3 weeks to everyone, and written submissions as well. And we will appoint nodal counsel in every matter, who will then prepare the common compilation. What we suggest is, instead of us really making a roll call,
We'll give the names of the nodal counsel.
if everybody just gives the name for each matter, the name of the nodal counsel, so that their names will be included in the order. So that
My only request is if your lordships can tell us the dates, because unless we know, we have to prepare ourselves for this. That your lordships should tell us in advance, that's all.
Certainly, what I'll do is, I'll prepare the calendar. I'll just look at how the calendar is situated for all the benches.
Correct.
And probably do that by this evening or by tomorrow evening.
Fair enough, fair enough.
That I can just sort of space them out. And if also on the same piece of paper, everybody can indicate, I mean, obviously these are not hard and fast, estimated time for the matters, because then I know how much gap to give before the next matter.
Fair enough, fair enough.
That may not be very accurate for the reason
Obviously,
that we don't have papers, we don't have the exact parameters of the matter.
Many of these matters have now been pending for 20 years.
Some of them can also finish in a day, some of them are very short matters also.
Yes.
Time limit is useful.
Yes.
Lord, there is one additional point as far as the tribunal matter is concerned, which is 705. What has happened is the referral order only refers to referring the money bill issue to 7 judges.
yes,
But
yes.
my lord, in para 118, the Honorable Supreme Court says the question as to whether all the tribunals should be shifted to an independent ministry has to be decided. This also should be referred to the larger bench of 7 judges. But in the concluding paragraph, that has not been added.
So we can, when we are formulating the questions, and when the matter is called out, we can always reformulate a question and
Because
May I suggest, my lord, if it appeals to your lordships, but after, my lord, your lordships stipulated date for us to, my lord, keep our house in order, my lord, the numbering, etc., is done. If your lordships can keep the matters again for directions, some questions may have to be reframed. Your lordships may individually give dates. By that time, we'll be ready with the time schedule, my lord, which we will take.
Instead of doing that, because then after we give directions, again, they will go back,
They may
by
delay the
about
matter.
4 weeks. We'll give sufficient time here. So should we quickly call out each matter and just find out what each matter is, and then, not more than a minute for every matter. So
Fair enough.
just let's find.
There is a problem.
Let's go with 701.
701, I'm for the, appearing for Mr. Venu Bhagat, who's for the appellant. He wrote a letter to the registry that he is unable to contact his clients whose firm is now defunct, and 2 of the partners have died. And the question involved, as he told me, was that whether there can be a sales tax on the sales tax for the goods sold, and is covered by a 6 judges bench of.
That has been referred to, sir.
Yes, yes, that is why it was.
So we may still have to resolve the question, irrespective of whether, somebody is available or not. We may then appoint an amicus to assist the court on the issue.
So I'm appearing for him in 2 appeals only.
And how many appeals are there in that batch?
I just,
There are 11.
yes,
Who's appearing in the other matters in 701?
That question arose under there are 9 matters in 701. In 701, there are 9 matters.
11 matters.
11 matters. I stand corrected. Maybe something is added.
No, not.
What about the other appeals? Is there somebody appearing in the other appeals in 701?
Yes, my lord. 701.
I am appearing in 7012, my lord, which is a matter of the state of Punjab.
For the petitioners?
That's
I'm appearing for the respondent, ma'am. 701.2.
And for the private parties, anybody else who's appearing? We'll list the matter sometime. So what we can do is maybe 701, we can list for directions immediately and then see if that really survives. If it doesn't survive, then we'll close it because now this is a legacy issue.
Very well.
All right. What about so we'll 701 jo hai na, keep it for just keep it for direction so we can spend 10 minutes and see if that matter survives from Punjab. So two.
Lordship, please, sir.
The privilege is of the Assembly, my lord, Tamil Nadu Assembly. My lord.
That's,
I
that's,
think the union
in
has
that
to be-
matter, because that's the,
All the states.
All right. So there we will
that's
give
the power
direction.
of the speaker to arrest, that's the issue.
Right. We'll give directions then, the usual directions in that matter.
Only one request, please.
Your Lordship issued notice to the Attorney General to assist the court in this matter. So that's why I'm here.
But, my lord, in few matters, though union has something to say, we are not parties. If your lordships can pass a general order, implementing union as a party, we'll waive. We don't wish to delay the serving, etc.
But you can, anyway, we can assist the
But
courts
it's
in
in
the
the
independent of that.
704.
We'll permit.
Formal that may be necessary, my lord, for us to file pleadings, etc.
All in the entirety of.
No, there are 2 or 3 matters where we are.
Our
no
speaker has nothing to do with the union.
But if we require some assistance from the attorney.
Okay, here I have no problem, but otherwise, Mother, it's an issue.
Anyway,
between
notice
the
has been
speaker-
issued to the Attorney General.
That's-
We will say that on the we'll permit the union
No
to be
problem, Mother, I don't say that, but
let them be there. We'll have some more assistance
No problem.
on this side as well.
no problem.
I appear for the,
To amend,
in 702, I appear.
to impede the Union of India. Mr. Tushar Mehta, Learned Solicitor General, appearing with that no further notice is required. On 701, 702. Just make sure that all the names are, yes, they will clarify that.
That I appear for the speaker of the legislature.
All right, so we'll give directions for listing 702. We have a few CBs which are already listed immediately, and immediately after that, we will take up.
Fair enough, fair enough.
All right.
703. Lord, as far as this is concerned, this is the Aligarh Muslim University matter.
Minority status.
Now, there are directions your lordship would have to pass. The first is in the High Court, notice was given to the Attorney General. So that may be done in this case as well.
Let notice to Attorney General.
The second is a little more complicated. The union supported the minority status both before the single judge bench and division bench. They filed an appeal against the division bench order which said that they are not a minority. They have now filed an affidavit in 2016 saying that they want to withdraw their appeal. Now their status would have to be determined whether they would be respondents.
That
because
is
they
when
would-
it is called out, my lord. That's a contentious issue.
Apart from the appeal by the union, who else has filed an appeal? There's other appeals as well.
The university itself.
There are 8 appeals, 5 by AMU, that's the university, and 2 by private parties. But this issue has to be decided,
This will have to be
This will
decided.
have to be decided, yes.
and it can be decided as a preliminary
No,
issue.
we'll have to decide the issue.
Yes.
When the matter is called out, we'll see
Good,
what the
that's
impact is.
The notice to the Attorney General.
With that, we've already issued.
I'm already here.
Lord, what I've done in this is I've framed 5 issues which can be uploaded to your lordships. Can we just put that down?
If you can share it with us, we can.
Dr. Dhawan, if you could share it with the Attorney General, so that, then they can respond to you, and when the matter is called out, we can, before we begin the hearing, we can finalize the
You've
issue.
already uploaded it, Vinod.
So kindly serve a copy on this. That's the request.
Absolutely, we'll argue it.
Very well.
704.
704, I appear for the state of Punjab. Because here the issue is that subclassification within the scheduled caste, the state had passed.
Chinaya.
That's right. So Chinaya has to be relooked at. Because the Learned Advocate General of the state is also appearing online. So Malaz may appoint Malaz from our side, Mr. Karan Sharma as the nodal counsel.
So, as I said, in all matters,
We'll give the
please
names.
give the two nodal counsels.
My lord, instead of troubling your lordships.
This matter will require hearing, my lord, because we have a category of Valmikis within the scheduled caste, my lord, which was under challenge and the High Court has squashed it. So we are in appeal.
What you can do is that we are circulating soft copies of everything now. So your note, your written submissions, etc., can be formed in a compilation, and the two nodal counsel will put everything together for every matter.
Nice.
Not necessary right now because it will just get lost in the papers. So it will be much better that you give it to the nodal counsel so that they are uploaded, and then we have everything down in one compilation.
In fact,
Yes.
in 704, I had appeared before the 5 judges bench for a private.
That
matter.
money
I think
bill issue.
It's a matter of importance whether the union may have to be heard.
No, this is the money.
Union may be implicated.
704 is going on.
704.
Yes, yes.
Union may be implicated. We'll waive that.
And 705 is the money bill.
705 is the reference in Roger Matthew.
Yes, now that's something that should be decided, Malaz, that's my request. Malaz, give it priority because that's a really live issue, Malaz.
All right,
That's my request. It cuts across, Malaz. But there are several.
We'll give that some priority, Mr.
The priority is your lordship's discretion. We would request your lordships may go, my lord, seniority. It's entirely my lord's discretion. We cannot have it. We can't decide priority.
We can't argue on this, Malaz.
Right, leave it to us. We'll take up that.
I appear for the respondent, Malad 705.
We can't decide priority based on political exigencies. That's all.
That your lordship will decide, Malad, which
Please decide, Malaz. I think there is some.
But 705, there's also an amendment by the.
706 is Subhash Desai, Malaz, that issue.
Where we referred it recently.
That only requires half a day, Malaz. That's not really, not a matter that will last very long.
Not very long.
Yes.
That's the review of the legal of Nabam Rebia.
That's correct.
Yes.
Nabam Rebia did.
So
Are you
that,
going to really press that issue, the reference of Nabam?
they should accept what we are saying, Malaz. This is not a matter, Malaz, that. This is,
We'll see whether.
yeah, that's clear, Malaz. That's the whole issue is very clear. It'll take only half a day, Malaz. That's it. Very clear.
901.
Excuse me.
Please, ma'am. 901, my lord, there are two sets of matters, one relating to MADA challenge to Chapter 8A, and one relating to the Maharashtra Rent Control Act. Which came.
Right.
So there are a series of orders which 3 judges referred it to 5. And
5 to 7 and 7 to 9.
my lord.
But now that has to be resolved one way or the other.
That's it. That's it.
Yep.
Interesting questions on interpretation of Article 31C, 39B.
Yes, Mr. Attorney.
There I left to appear for MADA and the.
I am for the state of Maharashtra.
Just the court appeal. Yes.
902.
So we'll again pass the same order. Please, before leaving, give us a list of nodal counsel because the whole purpose of this hearing is to get the matters ready for hearing in the next 4 weeks or something.
Well, in 901, I have circulated a note giving a background of those 3 orders, which were 3 to 5 to 7 to 9.
All right.
And because the reference has not been made specifically to any issue. Well, let's kindly look into that note so that it can be taken. Great.
In 902.
902, I'm appealing for the petitioner.
11 issues, my lord.
Appellants.
What is the issue?
It's about
India
land
Cements.
tax which was imposed on mining land, mineral land.
Under state tax on royalty.
So it was struck down based on India Cement.
India
was
Cement,
saying
yes.
its royalty is tax and therefore. And then Kesharam came subsequently where I also appeared, Lord, and then they distinguished that. Then subsequently in our case, Lord, Justice Kapadia, Chief Justice Kapadia, Lord, so he said, Lord, that there is a conflict between 7 and 5 and therefore.
Therefore, it's gone to 9.
My lord, one other thing in 902, apart from the 11 questions, what is actually the burning problem now? If your lordship holds that mining royalty is a tax, then the additional consequent question is whether you can levy service tax and GST on that tax. That is pending in Jodhpur, Madras, Assam. Against all the petroleum companies, we are paying royalty. And on that, they are demanding GST and service. Amounts have become very large now. So at the early,
This has to be resolved early. It's been pending for almost 20 years.
24 years.
Yes, the area is mounting, my lord, that's the problem.
And it's not good for anybody ultimately that these tax users.
Milord,
There
may
will be
I
a
say
problem
one
in
word,
payment
Milord?
also.
May I say one word?
In our favor.
Milord, subsequent amendments in MMDR.
because that what happens on royalty, we pay GST service tax, and that is not be able to set off to the consumer. So it's a cost to the oil companies.
All right, we'll list this. We will certainly give this priority in the 9 judges because it's in a 9-judge competition.
Yes, 9 judges.
Pending since very long, Milord, 2011.
So this is a question relating to industry.
Yeah, section.
Not very clear to us with respect. Now, the issue there in Bangalore water supply was with reference to municipal corporation. But the court has undertaken the task of examining whether education is an industry, sovereign functions.
Clubs, whether clubs are industry, sovereign functions, Panjara polls.
Bangalore water supply.
Bangalore water supply, 78 Supreme
So
Court.
the Cricket Club of India, all those judgments were reviewed, which in my respectful submissions were not within the scope of Bangalore water supply on the facts of that case. But since now it is referred to larger bench, whether we are permitted to address the court on all issues or whether with reference to the sovereign functions of the state, because it's
The Department of Narcotics is held to be an industry. So
I'm concerned with Forest Department for the state of Maharashtra.
And Forest Department also, there are a large number of cases across India. Irrigation Department, Forest Department.
State of UP also.
Even university. Then we get into Bangalore water supply.
Of course, Bangalore water supply now has stood the test of time for almost 45
It takes
years.
some time.
So
Because if the entire judgment is to be revisited, then it will take some time.
we take a call once the matter opens as to whether, it's desirable that a judgment which has held the field for 45 years should at all be reviewed. Or what is the great public injury that has happened now as a result of that?
Lordship can fix it between the Dussehra holiday and Diwali holiday, in between that.
In
which case, I think union may have to be heard on the
Yes.
industry.
So we'll issue notice to the attorney.
not a party, no?
And here also impede the Union of India.
Well, in fact, the law has been amended. So there is no need for this matter to go to a larger bench. Milord. That would be my submission.
Yeah, that you can argue when the matter is called out.
May I mention the matter, Milord, of 2006, which was where I've been referred to be taken up along with this, the main matter, Milord. My matter is not listed. So may I request that this...
Has that been tagged with the 9 judges bench matter?
Well, it's supposed to be taken up after the judgment of the 9 judges bench. Milord, this 2006 matter, I'll address your lordship.
Give a small note to the registrar listing who is in the court. And I'll take a call on whether this has to be placed with the 9-judge bench. Just give it to the registrar.
Very well.
By the evening, give it to him. I'll take a
Yes,
call.
by this.
Issue administrative.
Yes, much.
Yes, we are appearing to the state, no? In this matter, no? Then the issue is with regard to the state's jurisdiction to regulate industrial alcohol.
Synthetics.
Oh, synthetics and chemicals. That's a Sabyasachi Mukherjee judge.
I'm appearing for the
But there is one, we all appearing. Lordship may have to make the union as a party because it's British.
I think union, I have to be heard.
Yeah, we'll shoot the
Yes.
union. And wait.
They're not formal parties.
Yes.
There was one more request, no? If Lordship's deem it necessary. Because.
You're not going to do.
Yes. Union and the state with regard to regulatory power over industrial alcohol. And it's an important matter because for the states, it's an important matter. Their power to regulate has been taken away by synthetics. Now, Lord, in the synthetics itself, the Supreme Court considered all the states, all the states participated and argued the matter vis-a-vis the power of the union and the state. So what we submit with respect, subject to what Lordship decide, would it be appropriate for Lordships to call all the states over, notify them?
What do you say, Mr. Attorney? Notice to all the states in this?
Or can you website?
Yeah, all the states.
They are to.
Can it be on the website?
Say that liberty to notice shall issue to all the state governments and the governments of the UTs, as the case may be. Liberty to serve the standing council. Notice shall be served in the standing council for the respective states stroke UTs.
My lords, they are.
My lord, the notice to the Attorney General has already been sent, has been given.
But they have not been tagged. So we can provide with the list of those appeals which are pending, which will be tagged with this.
We can do that, or we'll hear the states here and this judgment will follow and.
But the sensibilities have to be also heard in them.
All right.
My only reason was not since in the
No,
earlier.
you're right.
all was
Really, we have to hear the states. States are vitally concerned.
Right.
It's really essentially a turf, constitutional turf between the union and the states. Because the law is, potable alcohol is in the jurisdiction of the states, industrial alcohol the center. But the states can pass legislation or regulations to ensure that there is no diversion of potable to industry or industrial alcohol to potable.
That's
Denatured.
the problem. The problem is otherwise. If Lordship could see till 1990, states were regulating industrial alcohol as if it was a privilege. It was 1990, this privilege theory was not exploded and the state's power was taken away by the center because IDR Act came in.
My lord, in fact, subsequently in 2005, the IDR Act has been amended and potable alcohol has been excluded from IDR. It's only the industrial alcohol.
The issue is, can you do it in IDR or the state's exclusive jurisdiction? How can you take it in IDR?
Right, we'll have to see.
Lord, before your lordship takes that matter, Lord, there is one confusion, if your lordships can grant indulgence. All of us are making this request. My lords have fixed 1 7-judge bench matter, my lord, on 5-judge bench on 17th. Now that is that Assam section 6A validity matter, my lords. But yesterday, my lord, we were informed that the entire week is a miscellaneous week. All of us are appearing, my lord.
That will now go to the 7th of November.
Please.
7th of
That's
November.
all we, my lord.
7th of November.
Milords, may I make one small request, Milords? Milords, I'm here, Milords. Milords, in 703, Milords, would the registry be able to provide us with all the pleadings in the pen drive form, Milords, because that becomes easier. These are very
all matters, my lord,
The courtmaster just told me that he's adding that as one sentence in all orders. The
all
registry
matters.
will provide soft copies to all the councillors.
In that regard only, Milords, I have to just make a submission, Milords. I had the occasion to go through some of the scanned records last night after the list was uploaded. There are certain, Milords, it is very convenient for us to actually download it from the e-filing to portal. But some of the scanned digitalized files have a watermark of draft or something else written in the entire paper.
That watermark will go now. In fact, that was pointed out to me last night by the registrar IT. He said, sir, there's a problem. We have scanned the files. Some of them have watermarks. They're dealing with it. Don't worry. In fact, it was brought to my notice last night before I was
In 902, Milords, I have one more additional submission to make. Milords, there are 6 transfer petitions in the batch. Milords, the batch has grown from 41 to 84 matters in 902. And Milords, 6 transfer petitions, 6 SLPs. then 4 writ petitions and 68 civil appeals. So well, it's transfer petitions, the main substantive challenge is pending somewhere else. In that regard, Lordship may have to take a call whether
to allow the transfer petition and bring those matters.
yes, that should not delay the
Yes,
hearing.
can you do one thing? If you can give the court master the list of the transfer petitions.
Yes, I have.
I'll list them for directions independently on some day. So that then everybody in those transfer petitions will be here and we'll take a call on what to do in those.
What can be done, either to segregate them and.
They are with the judge.
Allowed to intervene only, that.
Instead of bringing everybody here. That may
Otherwise,
be altogether better.
Just to intervene if they.
Somebody may seek
If
time
somebody
to
wants
file
to
reply,
intervene, they can
etc.
argue the question of law, assist us in the question of law. Better. I think that's better.
Grateful to.
Please, Your Lordship. No, correct. Follow on. Thanks. Yeah. Yeah. Lord, just to summarize, my Lord, there are 3 broad reasons why Your Lordship should be pleased to leave the issue of determination of stamp objections to the tribunal. The first is the doctrine of separability, which is housed in section 7.2 and 7.5 of the Arbitration Act, as well as, of course, most prominently in section 16. And the question whether, even if the main contract is null and void, whether an arbitration agreement survives, to consider that very question is directly covered by 16.1b expressly. 16.1a is separate, the arbitration clause is separate, and 16.1b directly covers the issue. Now, very briefly, therefore, whether the first argument is whether or not it is invalid, it goes to even existence, or whether it is only an irregularity or a curable defect. I'll come to that later, but assuming it is the worst, it's an invalidity. Even then, my submission is, by virtue of the doctrine of separability and competence, which our Act fully now recognizes, these are issues that must be left to the arbitral tribunal. And I'm going to save the court's time. I'm not going to take my lords through each of the judgments, but I've summarized from my revised submissions are now found in volume 1B, page 2. And from page 7 onwards of volume 1B, I've just extracted some of the major decisions, internationally as well as ours, on separability. And to which, of course, I'm going to add one when I show it before my lords. Page 7 of volume 1B. It's been added last night. Been uploaded now. My earlier submissions were in volume 1, but since we made a change, there was one mistake which we corrected.
Over here, it's updated submissions.
Updated submissions. I'm aware.
There are 38 pages.
38 pages. But that's because I've extracted judgments there, so it's easier for me to read from there rather than troubling my lord to go to the actual judgment. I'll be going to the actual judgments in only 2 cases, which are quite critical.
Is it Harbor Assurance Company?
Yes, it starts with that.
That's the Queen's Bench decision.
That's right. Oh. It starts with that Court of Appeals.
Yes.
Yes. If my lords just see para 9 onwards, Harbor Assurance arbitration agreement is a self-contained agreement. In Involnat, it was held that it's a self-contained agreement which is separable from the main contract, therefore has autonomous existence. In our own Enacon, expressly under section 16, your lordships have held that section 16 accepts the concept that the main contract and the arbitration agreement form 2 independent contracts. And then in para 83 again, the Supreme Court calls the arbitration agreement a second contract. Redfern and Funto also speak of 2 separate agreements, primary or main contract and a secondary contract. Then if we go straight to para 14, Gary Bond, the arbitration agreement may exist and be substantively valid, notwithstanding the non-existence, invalidity or illegality of the underlying contract, and the arbitral tribunal may and must consider challenges to the existence, validity or legality of the underlying contract because such challenges do not impeach the arbitration agreement. Then Fiona Trust. Arbitration agreement must be treated as a distinct agreement and can be void or voidable only on grounds which relate directly to the arbitration agreement. These are all very well settled principles, so I'm not troubling I'll just quickly go through this. Now, next page, again, the validity of the arbitration agreement is not undermined as a distinct agreement. The US Supreme Court has also taken the same line in Buckeye check cashing, which your lordships have followed. That despite the invalidity of the underlying agreement as a whole, arbitration agreement will continue to be enforceable apart from remainder of the contract. Para 17, page 11. In Ayaswamy, your lordships have held that the adjudicatory power of a tribunal remains unaffected by any objection to the main contract. And in Vidyadrolya, which I have not mentioned here, but which I noticed, my lord, during the hearing, which I'll be showing, again, paras 173, 174, expressly say arbitration agreement is a separate contract in itself. The Singapore position, which I've set out from paras 19 to 22, 23, really says the idea is to insulate the arbitration agreement, even though it may be integrated into a main contract, from objections as to invalidity of the main contract. So the law of separability is very, very well entrenched in our law. And my lords will notice that both in Ayaswamy and in Vidyadrolya, separability is spoken of as a concept which actually permeates the Arbitration Act. It goes beyond just matters where there is a challenge under section 16 to a decision of an arbitral tribunal. So although the legal fiction, if I may call it that, in 16 is for the purpose of giving the arbitral tribunal jurisdiction to decide its own jurisdiction, it is not restricted to that. It's a wider principle recognized under our law and under section 7.2 and 7.5 independently of 16. Now, the only reason I say that is that with this, squarely, any such issues, whether we call them existential issues, whether we call them only irregularities or curable defects, must, in the first instance, go to the tribunal. And your lordships are always there at the stage of the award or the order, whether under 37 or 34, to have a look at how the tribunal has exercised its jurisdiction. I have also set out at page 14 of my submission, section 5 of the Indian Stamp Act. This is really a matter ultimately that the tribunal will go into, but just for completeness. Section 5 of the Indian Stamp Act recognizes a position that a single instrument may pertain to several distinct matters. And in which case, according to the Stamp Act,
this is the second point you're making.
It's really part of this separability point. If it pertains to distinct matters, the aggregate of the stamp duties on each of those distinct matters must be worked out. Now, if an arbitration agreement is separable, then perhaps a tribunal may be persuaded to hold that there must be separate stamp duty and all. In other words, separately on the arbitration agreement, which is what your lordships have held in NN Global under the residuary clause, as well as substantively on the value of the main agreement. This, of course, is a matter for the tribunal. I'm not suggesting my lords should decide this. My lords have made it clear your lordships are not deciding chargeability. But I'm only placing it before my lords because this is how the issue will come to be decided. And at para 29 of my submissions, I've referred to your lordship's judgment in Chief Controlling Revenue Authority, which affirms a passage from Halsbury in relation to Section 5 of the Indian Stamp Act, that an instrument containing or relating to several distinct matters is to be separately charged as if it were a separate instrument. So even under the Stamp Act, there is some concept of separability. Now, it may be that a tribunal takes the view that no, stamp is payable only on the whole. Or it may be that it takes the view that it's payable separately under each. That's a matter of chargeability. But that decision, in my respectful submission, must be by the tribunal.
Forum is the only issue. It's the forum which is an issue.
That's
what
this
will
the
happen,
forum.
will it happen, not happen?
Precisely. Precisely.
The whole purpose is to shift the forum to the arbitrator so that arbitration proceedings don't get delayed at the threshold. You go there and then you argue it out if something is the consequence that is there. But the court under 11.6 is the only issue really which we are touching.
That's it. Now, not for that purpose, I want to show my lords two judgments, which my lords have seen, but I just want to emphasize certain different aspects of them. The first is my lord's decision in the Ayasami case, which my lords will find in volume 5A at page 1336. There are three important principles laid down here, which I want to just press into service.
3,000?
1336, page 1000 of volume 5A. This is 2016, 10 SCC 386. My lords would kindly turn to page 1359, para 33. Para 33 says, Section 16 empowers the arbitral tribunal to rule upon its own jurisdiction, including ruling on any objection with respect to the existence or validity of an arbitration agreement. Very important because existence, even assuming stamp goes to existence, it's housed with the arbitral tribunal under 16. 16(1)(b) stipulates that a decision by the arbitral tribunal that a contract is null and void shall not entail ipso. Yes. 16(1)(b) stipulates that a decision by the arbitral tribunal that a contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. Hence, the invalidity of the contract between the parties does not render the arbitration agreement invalid as a consequence of law. This recognizes as inhering in the arbitrator the jurisdiction to consider whether the main contract, other than the arbitration clause, is null and void. The arbitration agreement survives for determining whether the contract in which the arbitration clause is embodied is null and void, which would include voidability on ground of fraud, The severability of the arbitration agreement is a doctrinal development of crucial significance, for it leaves the adjudicatory power of the arbitral tribunal unaffected over any objection that the main contract between the parties is affected by fraud or undue influence. My learned friends, for the respondents in their submissions, have argued long and hard that the doctrine of separability should not be applied to a stamp issue. If that is so, even then, by virtue of section 16, that issue must go to the arbitral tribunal. The next para is para 46 at page 1366. I'll just read a small portion of it. At page 136 is para 46, my lords have cited Fiona Trust. And then at the bottom, placitum G. Arbitration must provide a one-stop forum for resolution of disputes. The Court of Appeal held that if arbitrators can decide whether a contract is void for initial illegality, there is no reason why they should not decide whether a contract is procured by bribery, just as much as they can decide whether a contract has been vitiated by misrepresentation or non-disclosure. So the second principle is also accepted in the Vidya Drolia judgment of a one-stop forum for adjudication. Deciding a stamp objection in court before making a reference will violate this principle as well. And your lordships have given the reason underlying para 46 in para 48, which is 1367. The basic principle which must guide judicial decision making is that arbitration is essentially a voluntary assumption of an obligation by contracting parties to resolve their disputes through a private tribunal. The intent of the parties is expressed in the terms of their agreement. Where commercial entities and persons of business enter into such dealings, they do so with a knowledge of the efficacy of the arbitral process. The commercial understanding is reflected in the terms of the agreement between the parties. The duty of the court is to impart to that commercial understanding a sense of business efficacy. So the second one-stop business efficacy, parties intended that one forum would decide all their disputes and it would not be split amongst different forums. And the third principle, a more general principle in para 53, 1369. The Arbitration Act should, in my view, be interpreted so as to bring in line the principles underlying its interpretation in a manner that is consistent with prevailing approaches in the common law world. Jurisprudence in India must evolve towards strengthening the institutional efficacy of arbitration. Deference to a forum chosen by the parties as a complete remedy for resolving all their claims is but part of that evolution. Minimizing the intervention of courts is again a recognition of the same principle. And the principle, of course, as we have seen, is housed in section 5 of the Arbitration Act, which has a very far-reaching non-obstante any other law. So that is Parliament's legislative intent reflected in section 5. Therefore, these are three principles. Now, these three principles and two more have also been categorically affirmed in the Vidya Drolia decision of your lordships, which is to be found in volume 5, page 76. The 5 principles that I rely on Vidya Drolia for. First is separability. Second is full competence, that is both positive and negative. Third is the prima facie test. Fourth is that even under 11.6a, only the contractual validity of the arbitration agreement is to be seen. In other words, coupled with the prima facie test, if the court is prima facie satisfied that there is an arbitration agreement within the meaning of the Arbitration Act, then that is all. Nothing more has to be seen under 11.6a. And the fifth is these principles of a broad pro-arbitration interpretation to respect party autonomy, and one-stop adjudication, presumption of that. These are the 5 principles that have been laid down in Vidya Drolya. And may I quickly run through the paragraphs? Both the learned judges have decided this. The judgment is found at page 76, 2021, 2 SEC page 1. First, para 126, if my lords would kindly go to.
Which volume is this? 26, is it?
At page 182. 5A, 182 is para 126. First is separability. I'll just show both the judgments are ad idem on this. Para 126. Page 182 of volume 5. My lords have it. Yeah. Para 126 covers both separability and competence. We would now examine principles of separability and competence. Clauses A and B to subsection 1 of section 16 enacts the principle of separation of the arbitration agreement from the underlying or container contract. Clause A, by legal fiction, gives an independent status to an arbitration clause as if it is a standalone agreement, even when it is only a clause and an integral part of the underlying or container contract. Clause B formulates a legal rule that a decision by the arbitral tribunal holding that the main contract is null and void shall not ipso jure entail invalidity of the arbitration clause. Successful challenge to the existence or invalidity or rescission of the main contract does not necessarily embrace an identical finding as to the arbitration agreement, provided the court is satisfied that the arbitration clause had been agreed upon. The arbitration agreement can be avoided only on the ground which relates directly to the arbitration agreement. Notwithstanding the challenge to the underlying or container contract, the arbitration clause in the underlying or container contract survives for determining the disputes. The principle prevents bootstrapping, as it is primarily for the arbitral tribunal and not for the court to decide issues of existence, validity, and rescission of the underlying contract. Principle of separation authorizes an arbitral tribunal to rule and decide on the existence, validity, or rescission of the underlying contract without an earlier adjudication of the questions by the referral court. Para 173 and 174 are the equivalent findings on separability in the second judgment, page 200 of volume 5A. Arbitration is a creature of consensus. It is completely dependent on party autonomy and the intention expressed in the agreement. A contract having multiple clauses, including arbitration agreement, can be divided into 2 parts. The clauses relating to the commercial relationship, i.e. obligations and duties of each party, can be referred to as the main contract. The arbitration agreement, so to say, is a separate contract in itself. And then his lordship finds that separability of the arbitration agreement from the main contract historically existed even in Roman law and later, of course, in German and Swiss jurisprudence. Now, competence. Again, para 126, I've shown my lords. Para 129, if my lords will also kindly see, is also very instructive. At page 183. Principles of competence have positive and negative connotations. As a positive implication, the arbitral tribunals are declared competent and authorized by law to rule as to their jurisdiction and decide non-arbitrability questions. In case of express negative effect, the statute should govern and should be followed. Implied negative effect curtails and constrains interference by the court at the referral stage by necessary implication in order to allow the arbitral tribunal to rule as to their jurisdiction and decide non-arbitrability questions. As per the negative effect, courts at the referral stage are not to decide on merits except when permitted by the legislation, either expressly or by necessary implication, such questions of non-arbitrability. Such prioritization of the arbitral tribunal over the courts can be partial and limited when the legislation provides for some or restricted scrutiny at the first look referral stage. Now, this is a judgment, I believe it's the first, which divides up even negative competence into express and implied, and that is correct. Because very often a section will not actually say a court should not interfere. But an interpretation of that section, given Section 5 of the Arbitration Act, leads to an implied negative competence or a stepping back, as it were, of your lordships at the first stage. Because the whole scheme of the Act, the architecture of the Arbitration Act, is geared not towards front-loading inclusion by a court at the beginning, but towards a scrutiny after an award is passed. So it's not the arbitration that is heavily supervised, it's the award that is looked at when it is challenged, or of course an order under 37, if there's an appeal. And the same thought permeates through paras 178 and 208. I won't read them. No, the equivalent paragraphs, I won't read them, are para 178 and 208 in Justice Ramana's judgment.
178 and 208.
178 and 208. The third principle, and this minute I want to place, because this is the prima facie test. We've heard a lot about Section 8 is only a prima facie approach. What is a prima facie approach? How does a court apply it? Para 147.11, page 194, tells us how to do that. The second sentence, the court as the judicial forum of the first instance can exercise prima facie test jurisdiction to screen and knock down ex facie meritless, frivolous and dishonest litigation. Limited jurisdiction of the courts ensures expeditious, alacritous and efficient disposal when required at the referral stage. So something which is ex facie meritless or frivolous. Ex facie, there is no arbitration agreement. That is something alone that a court will see under 11.6a. The rest, if there's even a dispute or a doubt, will be sent to the tribunal. When in doubt, refer, is what this judgment itself says. And a similar principle, I'll just mention the para number. At para 154.4, at page 196.
That's what we have said, even in the case of limitation, if you get a case under 11 where somebody's come after 10 years, 20 years, or something doesn't turn really on a very detailed interpretation.
On a demurrer.
Justice, I think, Justice Natsima and Justice Pardiola were sitting with me when we found a case like that. And then the whole object of sending parties to arbitration again it defeats the purpose of arbitration.
So without much inquiry, without determining some heated controversy between the two parties, if a court can ex facie see it, of course, that is a safeguard under 11.6a. No one is disputing that. But stamp will never be such a question, particularly because, as we have seen, it's a curable defect.
Bhavata, that's the whole thing, this Stamp Act, anything to do with stamp. If it has a possibility of being curable,
yes.
Let us say even recognize the possibility of being curable, then how do you throw it out at a threshold?
My lord is absolutely correct.
So, in any scenario, possibly, Stamp Act requirement in any formulation of it, any variation of it, I'm very doubtful that at all it can be looked into.
My lord is right. I'm going to place a judgment of your lordships on that immediately after I complete this, showing that it doesn't, irregularity in stamp or even non-stamping doesn't render a document invalid. Your lordships have held that. I'll place that. But very quickly, I'll just give the paras on this. I won't trouble my lord. Where the equivalent para is para 232, Justice Ramanna's decision, where he expressly refers to section 8. That is at page 234. And he says in para 233 at page 235 that the defendant has to establish prima facie case of non-existence. It's the other way around. The defendant will show that ex facie there is no arbitration agreement. Well, the fourth proposition, again, in the interest of time, I'll just give the paras. Paras 236 to 238 at pages 235, 236, relying on your lordship's Mayavati decision. Ultimately says it's only contractual validity of the arbitration agreement that has to be seen under 11. In other words, section 7, is it complied with? On the face of it, ex facie. If there's again, even on that, if there's a dispute to be gone into, it will go to the tribunal. But if ex facie, your lordship is fine. There's just no agreement, of course. And para 244.5 and para 146. They all go on the basis of this kind of validity. And my lord, I adopt Mr. Datar's submissions. I'm not going to repeat them. Under the Contract Act, what is not a valid contract or what is a void contract is only one which is voided under section 23 or under section 10. Nothing more than that. Stamp Act doesn't come into that at all, not even into the Contract Act.
We have elaborately at this moment.
Yeah, so I'm not touching that. I adopt that, my lord. And the fifth, my lord, set of paras in this judgment, I'll just give the para numbers. Paras 151 to 152, page 195. And para 220 at page 230 is again the principles of a broad pro-arbitration interpretation and a one-stop forum for adjudication.
What is the latter para?
Para 151, 152.
195.
At page 195 and para 220 at page 230. They speak of a one-stop adjudication presumption. You start from the presumption that everything goes to the tribunal. Now, applying this to 11.6a, It's not that because the word existence is used, everything coming under that umbrella of existence has to be gone into. The legislature has said confined to the existence, and given the principles under Section 5 and these very salutary principles of law, a court would restrict by way of an implied negative competence, even under 11.6a, to an ex facie examination. Now, my lord, this is more so because of the next point, which has been argued. I'll just point out what I think is relevant and which has not been shown to your lordships. Under the Stamp Act, 1, non-stamping or understamping does not result in an invalidity or voidness. And 2, it is a curable defect. Now, if my lords kindly turn to my written submissions, volume 1B at page 15. I won't read all of them.
It's also waivable. You can waive it because.
And one can waive it. My lord is right. In fact, there are 3-4 sections which I want to just point out. Again, I won't read them. They've been read. Barring one, they've been read to my lord.
Waiver is also by conduct. It's far more liberal. It doesn't have.
My lord is absolutely correct. And if that is so, then under 11.6a, how will a court go into that? I'm obliged. I'm obliged. May I, my lord, adopt that as my submission? I think that's very well put. In fact, as Mr. Banerjee also argued, an 11 court is not even a 2-1e court. Whether it can take evidence is also a question. But therefore, it's impossible to go into these disputed questions under 11.6a, despite the use of the word existence. That has to be read purposively as meaning only ex facie if there's non-existence. There's a probability of existence, it must go to the tribunal. Now, curable defect and invalidity. The first point. Section 35 is very clear. It visits a non-stamped or not duly stamped instrument with only 2 consequences. One is it is inadmissible in evidence. And the second is it shall not be acted upon. And my learned friends have emphasized the second, not be acted upon. And they have tried to elevate those words to unenforceability leading to voidness and invalidity. I'll presently show why that can never be so. The curable, where the defect can be cured is section 36 we have seen, where once an instrument is already admitted in evidence, no stamp objection can be taken to its admissibility later. Section 37 and sections 42, which I don't believe have been shown, 42 I don't think has been shown to my lords. But 42 only allows the collector on payment of duty and penalty to stamp the document, and after stamping, then it can be admitted in evidence, and the shadow, as it were, of section 35 is lifted. In NN Global 2, and Mr. Datar has pointed this out, there's a slight contradiction because in para 108, it is said this invalidity is not in the sense of being stillborn, but in para 103, it says it's bereft of life. We leave that aside because, in fact, your lordships have held very clearly that no invalidity results. I'll come to that just a little later. I will make 2 points before I come to that. My lords have seen Hindustan Steel. The judgment in Hindustan Steel. And my lord, I've set this all out in my written submissions, pages, paras 32 to 47. So I'm not going to read it all. I'm running through this because much of this has been argued. I've set out the extracts from the judgments as well. Paras 32 to 47, starting at page 15. But I want to make 1 point. Hindustan Steel we have seen, and it is directly on point. about curability. But there's another aspect your lordships may take into account. There's a judgment of your lordships in a totally different context under FEMA, in the Vijay Karya case, which my lords will find in volume 5A, page 1545. I'm not even asking my lords to go to that. But the principle in Vijay Karya's case is this. I've referred to it at para 37 of my written submissions, and the judgment is found at volume 5A, page 1545. Citation is 2020 11 SEC, page 1. The relevant
Page number?
The page number is 1545, volume 5A. And at 1632 is para 88, where your lordships have laid down a principle as to what happens when something is capable of regularization or post facto permission in the context of FEMA. This was that whole series of foreign awards coming. It's a general problem.
A very small niche point, which is that looking to the nature of Stamp Act.
Correct.
Are we required to look into Stamp Act at all under 11.6? So it should be left. This is all.
Yes.
Why should we go here and there on the issue?
Only to assist that conclusion that if it's a regularizable, curable defect, then your lordships, even in the context of other statutes such as FEMA, which also have a public policy connotation, have said the transaction is not voided. That's what para 88 says. The transaction is not voided because it's regularized. That's the only principle I want to cull out from Vijay Karya, but I'm not taking my note. I've set out, Vinod, I'll just give my lords the reference in my submissions to the Singapore position on stamp expressly, my lord. My lord sees paragraph 80 of my submissions. Para 85 onwards, my lord, page 33. They have similar provisions. It's not that they don't. My lord sees para 86. (51)(1) of the Singapore Stamp Duties Act corresponds to our section 33, the impounding section. And section 52 in the next para corresponds to section 35. Same language. Not admissible in evidence, must not be acted upon. Identical language. And in para 88, I have referred to one decision of the Singapore courts, where it is categorically held that this is only a rule of evidence and does not affect the validity of an unstamped document. That is in this Muhammad Amin bin Muhammad type case. The case, I'll just state for the transcript, is found in volume 5B, page 4678. Even in NN Global, Justice Ravi Kumar at para 182 accepts that stamp duty defects are curable. Now, my lord, one other internal piece of evidence to show why the words shall not be acted upon can never be equated with voidness or invalidity. If those words were equated with voidness or invalidity, then there's no question of curing a void act. My lords put it to me. So the fact that you have provisions like 36, 37, 42 itself means shall not be acted upon in 35 can never be extended to an infirmity of invalidity or voidness. That's not what Parliament intended. Now, if my lords kindly go, and it will be very quick with this, my lord, page 19 of these submissions of mine, I've set out reference to a judgment of your lordships on this. Para 44 of my submissions. In Thiruvenkandam Pillai's case, Justice Ravindran's decision, 2008 for SCC 530, and I'll just read para 13, which I've extracted. It's in volume 5A at page 702. But I'll just read para 13 from here. The Stamp Act is a fiscal enactment intended to secure revenue for the state. In the absence of any rule requiring consecutively numbered stamp papers purchased on the same day being used for an instrument which is not intended to be registered, a document cannot be termed as invalid merely because it is written on 2 stamp papers purchased by the same person on different dates. Then the next sentence, even assuming that use of such stamp papers is an irregularity, the court can only deem the document to be not properly stamped, but cannot only on that ground hold the document to be invalid. Even if an agreement is not executed on record stamp paper, it is admissible in evidence on payment of duty and penalty under section 35 or 37. If an agreement executed, so on. And the last sentence, but admissibility of a document into evidence and proof of genuineness of such document are different issues. Your lordships have held this under the Stamp Act. And para 45, I've set out the instructive judgment of the Calcutta High Court, which Mr. Banerjee also referred to, and Gulzari. And the next para 46, a number of other courts, Bombay, Andhra Pradesh, Calcutta, have held this. It doesn't need to voidness or invalidity. So this is too well settled a proposition. I mean, just 2 points and I'll be done. One is, we have viewed this matter from the perspective of section 11(6), court appointment of arbitrators. But there is in existence a huge body of appointment of arbitrators by individuals. There's no dispute to start with. There's also increasingly growing appointment by arbitral institutions. In fact, the policy of the law is to encourage the interposition of arbitral institutions. There's a proposed amendment which is not yet notified.
All those cases that will go before the arbitrator.
Correct. So I've also said...
Argument can be in 11(6), why take a different view than what would happen in...
That's right. And I'm obliged. The point I'm making here is your lordship's view on 11(6)(a) must try to harmonize even appointments by institutions.
With how arbitration in other areas, in other methodologies take place.
So, for example, all arbitration institutions have these rules. SIAC, for whom I appear, has rules 28.1 and 28.2, which essentially an objection as to jurisdiction, as to the existence of an agreement can be initially raised before the full court. The court has the jurisdiction at that stage to knock out a claim if it is prima facie satisfied. Again, the prima facie test. Otherwise, it sends it to the tribunal for a fuller decision. And I may only ask my lords to mark 5 or 6 paragraphs of Justice Roy's decision in NN Global. That is paras 368 to 376, where he surveys the rules of several leading arbitral institutions. All of them have a prima facie test at the first instance. Para 368 at page 462 of volume 5A, up to para 376 at page 466. And he also refers to the Justice Sri Krishna report, which recommended encouragement of institutional arbitration. Because if my lords don't hold the prima facie test in 11(6)(a), then individuals and institutions will be left in a quandary. What do they do? Because the observations in NN Global, albeit in the context of section 11, will apply to them as well. If it is held that an unstamped agreement is void, what do they do? Now, one further problem. Neither individuals nor arbitral institutions are empowered to receive evidence. So they would not be covered by the bar under section 35 of the Stamp Act, because that only applies to persons who are authorized to receive evidence either by consent or by law. Or indeed, they would not have the power of impounding under section 33. So they can't impound. There's no bar under 35, but there's your Lordship's decision in NN Global saying void and non-existent. So they are in a complete quandary as to what to do. Therefore, it is important your Lordships decide this matter holistically, because otherwise a very important segment gets left apart. And there I must say, my learned friends, I've had a cursory look at their submissions. Mr. Shyam Devan, I'll just note it for the transcript in para 4.7 of his submissions, accepts that arbitral institutions have no power to impound, but they might be able to appoint a tribunal because section 35 is not applicable to them. And Mr. Nakul Devan at para 23 also says arbitral institutions have no power to receive evidence. Equally, Mr. Shyam Devan at para 4.7 agrees that an arbitral tribunal has the right to impound a document under section 33 because it is authorized to receive evidence by consent of the parties, not by law but by consent of the parties, and therefore it can impound under 33, which is my submission as well. And one more reason why it should go to a tribunal. And Mr. Nakul Devan at paras 24 and 25 finally comes round to the same view that even under 11 your Lordship should be pleased to refer it to the tribunal. Mr. Shyam Devan raises the point that it may not be convenient for an arbitral tribunal to do this. It doesn't have the infrastructure to impound, send the document to the stamp authorities. But that's an issue of convenience. It's not an issue of law or jurisdiction. But I'll leave it to my learned friends to satisfy my lords why it should not be sent to the tribunal. Now, one point and then I'll draw my conclusions very briefly, Mara. I'll just give the pages because it doesn't arise before my lord, but it puts the matter in perspective. Paras 48 to 58 of my written submissions, pages 21 to 24, deal with this whole issue of who is entitled to impose stamp. Does it come under list 1 and therefore under the Indian Stamp Act?
You need not go into that actually.
They're not required to.
They're not.
But
You saw those entries,
that's
you
right.
don't have to go into.
I only wanted to say one thing and I'll be done with this. Under the state stamp acts, the residuary articles have stamp duty of 50 rupees and 100 rupees. Now, the process of arbitration ultimately cannot be held up for 50 and 100 rupees, which can easily be cured because all the residuary articles are low figures. NN Global, I'm not going to analyze again. My learned friends have analyzed it. I don't. Not just my conclusions. First is that your lordships should be pleased to adopt a purposive interpretation to uphold the intent to arbitrate. In deference to party autonomy. And I've given some cases where your lordships have done that under the Arbitration Act in Nandan Biometrics, etc. I've mentioned them in my written statement. The second is Section 5 of the Arbitration Act must be given full effect. It's a very wide non-obstante. And the Arbitration Act is a complete code. Your lordships in the Amazon case, I'll again just give the para number, para 43, and the judgment is found in volume 5B at page 623, have held that the new Arbitration Act with the amendments is a complete breakthrough from the old position. Therefore, every provision of that act must be interpreted given the overarching principle of Section 5 and the principle of an implied negative competence. The third, as held in Vidya Drolian, that so long as an arbitration agreement satisfies the requirements of the Arbitration Act ex facie by adopting the prima facie test, there's no question of a court holding up the arbitral process by entering into an examination of whether duty is paid, whether it's understamped, under which article it falls, etc., etc. The fourth, since a tribunal is authorized to receive evidence, Section 33 of the Stamp Act will apply to it squarely. It can impound the document and start the process of stamp collection. There's no reason why a court which is, courts are already clogged with so many matters, why they should be clogged up into this? Fifth, such an interpretation of 11(6)(a) will also harmonize the process between appointments by courts, by individuals, and by arbitral institutions. An arbitral institution certainly will take just a prima facie look before the tribunal is appointed. An individual may not do that. The one who wants to refer to arbitration will refer, the other one will go to section 11. So it's unlikely, but sometimes individuals do, because very often these objections are raised halfway through an arbitration. So it's not unheard of. Then, my lord, 6, the trend is towards encouraging institutional arbitration. The Amazon case has said so, and your lordships are familiar with the Sri Krishna report, which has said so. And therefore, to leave institutions in a quandary and to effectively block the process of institutional appointment by saying go into stamp objections will not subserve this broader public policy objective. And lastly, there is also a trend towards investing arbitral tribunals, a parliamentary trend, towards investing arbitral tribunals with powers of a court. This is the legislative prescription of Parliament. I'll give a few examples. The amendment adding 17(2), which prevents a Section 9 court, which effectively prevents a Section 9 court from giving interim reliefs, because under 17(2), the orders of an arbitral tribunal are given the force of law of orders of the court. And corresponding provision is 9(3). Section 11(6)(a) itself. Section 8 was amended in 2015 to include prima facie, to bring it into line with 45, where under Shinitsu, your lordship said, well, only a prima facie look to a foreign arbitrations. And even 12. Under Section 12, even impartiality and independence, the first objections must go to the tribunal itself. So the whole trend is empower the tribunals more and more in deference to the principle of competence. And this, in my respectful submission, will subserve the scheme and object of the Act, minimum interference of courts, party autonomy, and one-stop adjudication. And ultimately, in a lighter vein, this might encourage the stream of trade and commerce, and ultimately more stamp duty might result as a result of this, rather than holding it all up for stamp objections to be decided by courts. I'm deeply grateful for the time I've been given.
Who are you appearing for now?
My lords have been grateful when I was appearing in the Constitution bench for inviting submissions. So 5 to 7 minutes, my lord.
Just one thing.
Yes.
We have to wrap up the proceedings today.
Yes.
It may not be in the interest of anybody that, we keep it on.
I understand.
So what we'll do is, we'll look at the submissions of all the interveners.
Yes.
Would have much liked to hear you all. You've put in a lot of industry. Please rest assured we'll read all the submissions of the interveners. If we have something at the end, in response to what Mr. Diwan has argued, and since we have heard Mr. Datar, Mr. Gaurav Banerjee, and Mr. Daras Kambata on this side, in rejoinder, if we have some queries, we'll put them to the intervener. I think that may be better.
2 minutes for one aspect.
We can't give 2 minutes to everybody. Thank you. Yes, Mr. Diwan. We'll try. Do this. Give us your submissions. Yes, Mr. Diwan.
We've narrowed down the controversy, Gaurav. Therefore, there's really nothing to be added.
Nothing to repeat. Only then I would just have pointed out the relevant pages of my written submission. That's all.
So that we'll read it, don't worry. We'll read it in.
Thank you. Yes, we'll read the submissions. Yes, Mr. Diwan.
I appear for respondents 1, 2, and 4. I appear with Mr. Nikhil Nair. We will divide our submissions. For respondents 1, 2, and 4. I'll request the court master. Yes, sir.
One thing, since we have now renamed the title of this proceeding, the object was also to assuage your concern on behalf of your client that we shouldn't look into the curative aspect, or that you have a preliminary objection to the curative issue. We'll be sending it back to
Yes,
the
but that may
five-judge
not,
bench
so
on the
that
curative.
after hearing us on curative, your lordship may consider whether that's the correct course at all. Because in my respectful submission, that may not be the correct course.
We
So I'll
really
be
want
brief.
your we want your assistance on the question of law.
I'll do that as much as I can, but we'll do that in 2 stages.
To your client on facts and whether curative should be exercised, we'll leave it to the five-judge bench, and we are not going to come in the way of your client saying that, look, please dismiss this curative because they have no case on merit.
I think, okay, so let me, I've understood what your lordship is indicating. Now let me contest that position and suggest that there is a better way forward.
Yes.
So let me first, so I am going to be making my submission very rapidly because of the constraint of time. I will state my points. I'll request the court master, if you consider it convenient, to hand over, I've given a list of the Constitution of India, the Stamp Act, the Arbitration Act physically, because it may take less time that way.
We have it with us.
Now, let me just, so I have 2 broad sets of submissions. I am first setting out my points with regard to my first set of submissions. The first submission is that our court, which is the Supreme Court of India, as we understand it, is a means and ends institution. We are very particular about means and ends when it comes to courts below, when it comes to government authorities, when it comes to citizens, and most important, when it comes to ourselves. Because the reputation and credibility of our institution rests on the foundation that we reject expediency. We do not. We have sometimes very honorable objectives, but we do that as the apex court in our country, following, reaching those ends by permissible means. And that is going to be my first point with regard to means and ends, the importance of means and ends, and the importance of the nature of jurisdiction which your lordships is exercising. That's my first point. I now come to my second point. Let me indicate what we are not exercising first. So first and foremost, as your lordship correctly put to me, that look, we have relabeled this, and I'm very grateful for that, because I think it really helps, because the parties know, individuals who read the judgment know. So I think it's very beneficial to have an appropriate caption for the case rather than this. But the caption and altering the caption, does it alter the nature of the jurisdiction which you are exercising? So I ask myself a simple question. What are the jurisdictions which this court indeed does exercise? Are we in the realm of appellate jurisdictions? The answer is no. It's not appellate constitutional. It is not appellate statutory. Is it review jurisdiction? The answer is again no, because review, as I will indicate to your lordships, has been rejected. Are we in a jurisdiction which is original, like 131 or 32? The answer is no. Are we in a jurisdiction of discretionary appeal? The answer is no. Are we in a jurisdiction on an opinion which the President of India seeks by way of a reference? The answer is no. Are we in a transfer jurisdiction? The answer is no. So then what is our jurisdiction? What is this panel constituted exercising? There must be jurisdiction. This is the primary function of every court. You must be satisfied. I'm only saying that. You ought to be, I can't say must be. You ought to be satisfied that the jurisdiction which you are exercising in a panel of 7, I'm sorry.
Where a 5 judges constitution bench has found the view taken by earlier 5 judges bench.
Yes, yes.
To be prima facie not correct.
Correct.
Is a reference to 7 judges not called for?
Yes. So let me answer that straight away. If in an appropriate jurisdiction, I answer that straight away. If in an appropriate jurisdiction, your lordship's exercising a jurisdiction, your lordship finds that a 5-judge bench is not appropriate prima facie or otherwise, by all means you have the power to do so. So I concede and I accept that. But not in the curative jurisdiction. Now so let me answer that question straight away first.
The only problem is,
yes,
exactly.
I'm so sorry. No, there are fundamental issues. I'm sorry.
That doesn't really survive, subject to what you say.
Yes, of course.
Because even when you were arguing earlier,
yeah,
you said this is not a case for curative.
Sorry?
This is not a case for curative.
That's my submission. I mean, it's ultimately for the court to hold.
Case for curative, you may be right, you may not be. We can't
Correct,
do that.
correct.
But you said, look, don't in a curative petition appreciate these submissions.
I'm sorry?
Don't appreciate these submissions or debate these submissions in a curative petition. Correct?
Yes.
That was your submission.
That's what means and ends is about. You must be exercising a legitimate jurisdiction. Legitimate meaning is not that it's illegitimate to exercise. It is curative. The point I'm making is your lordships are sitting exercising a seven-judge bench, and I have no problem with seven-judge bench at all, or nine-judge or whatever. But the issue still is the core nature of your jurisdiction today is curative and nothing else, which takes us to, I'm sorry.
When a position of law,
yes,
you're a constitutional court.
Yes, of course.
When a position of law is liable to cause grave public injury.
Yes.
Public uncertainty.
Correct.
And grave unsettling in the world of business and investment.
Yes. Yes.
Surely, the point of time at which the controversy should be resolved should not be left to the vagaries of future litigation. Is the duty of the court to seize upon the opportunity?
Yes. Answer is yes.
And at the end of it all, we may still dismiss the curative petition against you.
So the answer is yes.
Because we are equally conscious of the need to do justice to the facts of that case. So the curative petition can be still dismissed after the decision of this court is rendered.
So let me answer.
Setting the law correct.
So Manoj, let me just answer that. First and foremost, if this court finds in an appropriate jurisdiction and in an appropriate cause that there is some decision which requires reconsideration, which is absolutely your function, and I would take it higher, even perhaps your duty to correct the position in law, it ought to be, as we understand it, in an appropriate proceeding. So now let me just answer the questions which your lordships have put to me. There are two ladders here. The first ladder is a curative ladder. As we understand it, the ladder narrows in the sense, in our understanding, review jurisdiction is narrower than the main appeal, and curative, in our understanding, is narrower still than review jurisdiction. If that be so, then this is a very narrow issue. So I come to my second point. Curative, as we understand it, as understood by this court, and I'll place those decisions, is with regard to doing justice for a particular individual cause. When we go to Hurrah, your lordships will see, it's a case in that case to do complete justice, that individual case. The curative jurisdiction, there may be several situations where you have incorrect law or something which is staring in the face. We don't accept that we'll come to, of course. But it's very important to follow the means and ends test. And I'll tell your lordships why. NN Global ought to. It may come up on an appropriate separate ladder. Curative is a three-rung ladder, as we understand it. The first rung is the disposal of the case itself. The second rung is there must be a disposal as far as the review is concerned. And the third rung is thereafter a curative petition with all the safeguards that the court has laid down. That's the three-rung process of reaching this court in curative jurisdiction. Now is a submission. You cannot bypass these three rungs because, and let us remember, the curative jurisdiction, although now in our Supreme Court rules, your lordships have continuously exercised, it's a self-created jurisdiction. It's a jurisdiction because the demands of justice sometimes stare an apex institution like your lordships in the face. And oh my, how have we allowed this to pass? And in a situation such as that, for that individual case, yes, you have created this very, very narrow jurisdiction to yourselves, required an appropriate certification, restricted it to grounds, and said that and only in those cases, even though you don't find any provision in a statute or the constitution, we will, because it's our paramount duty, and you trace it to 142 as we understand. So 142 generally may be wider. 142 as a source of power for creating curative and for exercising curative as we understand it is limited to a cause, to a particular individual cause. That cause may in certain situations affect a large number of people. I accept that. But here, what has happened is, now Manoj, I'm just answering the question. Sorry.
There can be a legal cause and there can be a factual cause.
So, yes, let me answer that.
Factual cause has been segregated, as the Chief Justice put to you.
Yes.
To keep the curative aspect, in a sense, out of it.
Yes.
But we do believe, and seven of us do believe, that there is an unsettled legal position about the facts, which has own ramification, and the Chief Justice put it, it becomes the court's duty to in its endeavor.
So I quickly end that. I quickly answer that. My answer is yes, it is the duty of the court. But if we are right on means and ends, then it's a duty of the court when and where. So I'll come to that straight away. It is the duty of the court when NN Global in an appropriate proceeding is doubted, the 5-judge bench. It goes by way of review and then it is before curative. That is a separate ladder. And it's important to maintain these ladders. It is not permissible, according to us. I mean, it's not permissible, it is not desirable, and according to our understanding of the law as laid down in the judgment so far, it is, your lordships have restricted curative continuous. I mean, restricted in the sense when the justice of the case demands, so I'm sorry.
Difference of perception on this issue.
Yeah.
The issue is that someday your submissions are bound to be affected or colored by the fact.
No, but
why in my curative petition?
Sorry?
Why in my curative petition? Why are you doing this in my curative petition? That's the bottom line of what you are saying.
No, that's not. There are two elements here. The first element, your lordship is right, that it is in my, because I'm briefed in this case, so I have to say that please, I mean, don't upset my apple cart.
Correct.
My agreement, by the way, I mean, this is quite amusing. My arbitration agreement is of, your lordship will not dare suggest the year. It's of 1997. My arbitration agreement is of 1997, and I was telling you, 26 years down the line, we are thinking of appointing an arbitrator. And I mean, what a joke. But for the fact that it's a serious question of law, which your lordships are considering. Sorry.
I told my Chief Justice on the lighter side in Chennai, I have had to refer an arbitration in the year 2015, an application filed in 1999. It was a live dispute. It was accepted as a live dispute and I had to refer. The unfortunate part was that the only unfortunate part was the application was not taken up. So therefore, we are not getting into the facts of it. Therefore, I feel you are more troubled by the fact that why are your clients being troubled in a curative jurisdiction?
So I will
therefore at the threshold itself, looking to your submissions on the earlier date.
Yes,
the files referred to the same.
Yes.
We thought we had taken care of this issue by not looking into the curative issue at all. And that's something, Mr. Datta. So the curative will be.
But the question I asked, then what are, I mean, of course, a Chief Justice can constitute a panel of 7. But then what's the jurisdiction that this court is exercising today?
Determining the legality of the view taken by a
that's an opinion which or a reference which the President of India has sought. Which is this jurisdiction? It is only curative. Anyway, let me just, sorry.
Mr. Diwan, your basic objection seems to be that while examining a curative petition, the legal ratio raised in the decided in judgment should not be relooked at by a larger bench.
I'm sorry, Manoj, read last.
While examining a curative petition or while deciding a curative petition, the legal ratio raised down by a 5-judges bench or any smaller bench should not be looked into. That's a larger perspective, but in a given case, where we find that the business ramification or other issues have arisen which have raised some doubts and issues. Why not examine it? We are not saying that curative petition is going to be examined on facts itself separately. So if there is some doubt or debate on the legal principles laid down, legal ratios laid down, which have wide ramifications in fact, why can't we go into that?
No,
why should we?
I'll tell you what.
It's really speaking, here the means are right because if there is some issue which has arisen, which has led to a lot of disturbance, then it's the right means to also check it. It's not something that we are usurping a jurisdiction which doesn't rest with us. We are all adjudicators. We have to adjudicate. We keep on re-examining ourselves, correcting ourselves. That's our jurisdiction.
So now I'll follow. So let me just be very brief on this point and let me give you the page numbers and the dates. May I just indicate it? I'm not, please don't misunderstand me. I'm not saying that a 7-judge bench can't overrule a 5-judge bench. That's not my case. My submission is, of course you can. But if we are a means and ends institution, then it ought to be in an appropriate packaged case and proceeding. And this may not be an appropriate proceeding for 2 reasons. Now let me just, for several reasons, let me just indicate those. And since your lordship, I'll state the points. If your lordship wants me to go to it, I will go to it. But I mean, we have the pages here. So the first point is that the ground given, please just note this. The first point is that the ground given insofar as the curative petition as contained in the certificate is that there is a reference which has been made to a larger bench in NN Global. So this is the primary ground. This, in my respectful submission, cannot be a ground for the purposes of issuing a certificate. Your lordships have deprecated certificates of this type, and I believe it ought to be deprecated here merely because there's a reference which has been made to a three-judge bench. So that's absolutely no ground. Now, if there is no ground which is made, which is sustainable insofar as a curative petition is concerned, the question of igniting the curative jurisdiction does not arise. So this is one primary set of submissions that I have. If your lordship likes, I can give you sorry.
Security with it. That's the. When 5 judges may be sitting in curative jurisdiction, dealt with it. He is not denuded of the power to constitute a larger bench to examine the question.
I agree that. I agree with you.
That's all we are doing.
So, Malot, may I just say this?
Even there, we did not let them argue even further. Is something which needs to be looked into or relegated to arbitrator. There also we have not permitted them to expand the contour. We have some of them.
So anyway, your lordships have followed my point now. So I'll just give you the points. So the first point is
we are leaving it to you to fight another day on the curative petition. We are not dealing with that aspect. We are today not peacetaking.
I think, frankly, I mean, I'm just making a suggestion. If you do find in my favor that the essential elements for a curative jurisdiction are not made out, then my respectful submission would be the appropriate course is to decline to exercise this jurisdiction, because you are exercising no jurisdiction other than curative today. When you pass the order suggesting that you are clarifying it, etc. There is, sorry, that's my understanding of the law. But I mean, if your lordship finds that there is some other jurisdiction which is also being exercised over here, I don't find any. Sorry.
We've said repeatedly that so far as the curative matter is concerned, it will be heard by a 5-judge bench. Whether they agree, disagree, dismiss the petition in the facts of the case is a separate matter. But on a general principle of law, 7 judges of this court felt, led by the Chief Justice, who exercised his discretion. We have segregated it yesterday. We have said we are only.
So let me just proceed now. I've followed the point. So let me just state my points, and then your lordships will consider them appropriately. So my first submission is that by relabeling it as in re, etc., it doesn't alter the nature of the jurisdiction or exercising. That's my understanding of the law. The nature of the jurisdiction remains the same. That's point one. Point number two, if you are choosing to exercise curative jurisdiction, which of course you may, there are well-settled parameters, and I'm just indicating those parameters. I'm just mentioning them because they're in our submission. I'll list them. Sorry.
Mr. Davin, problem is, Mr. Diwan, that we are not looking into it. So you're arguing something which we are not looking.
But if it's curative and then your lordship say that it is.
See, it's a catch-22 situation.
It is a catch-22.
You can't do it in a curative because there are restricted parameters. Okay.
All right, let's keep that aside. Let's keep that argument.
We are not doing it. We are only looking to one proposition of law. He holds the curative.
All right.
Whether in case of a 11-6 jurisdiction,
all right,
stamping is something to look about.
Okay, so now let's drop this. Now, I'll next 3 sentences, I'll try and not use the word curative. Supposing in a theoretical situation, a very, very wrong judgment comes out by this court, and it is brought to the attention of the Chief Justice of India or senior judges, etc. That look, this looks, extremely wrong and very perilous. The question I ask myself is that can the court thereafter constitute a bench of a larger panel, put a label in re, and then decide the issue to overrule that? I don't believe that is acceptable. That's my understanding of the law. I believe that can certainly be done in an appropriate case. An appropriate case comes up. That's what means and ends is about. But not, sorry, that's our understanding.
The impact of a wrong precedent is so severe.
Yeah.
And as our history has shown, by the
Yeah.
time you actually get a case, an appropriate case, what you have to ensure is that you do not confine your arguments only to one or two.
Yeah.
Therefore, we have invited a broad diversity of views.
Correct.
On this side,
Yes,
on this
yes,
side, we
yes.
have, that's the
So
idea.
let me, Manoj, move on. So Manoj, I said I won't use that expression. My understanding of the law is merely because there is a wrong judgment. Our understanding of this institution and its working, our understanding of this institution and working is that we improve, we self-correct, but there are methods and ways of doing it. And I am suggesting to your lordships that this may not be the appropriate way of doing it. Your lordship's answer is we are keeping your objection alive for another day. Fair enough. But then what's the nature of the jurisdiction in arriving at this conclusion of whether X is right or whether wrong? It is the jurisdiction which I said I won't speak about. So that's the very jurisdiction. Now, if that's the jurisdiction, then please follow the parameters. Now I move on. You may just note that in my case, there is a 337 days delay in file. So I've said the certificate isn't there in terms of Rupa Hurra. I have respectfully submitted that the agreement itself, of which the arbitration clause of 1997, so please keep that in mind. There is a 337 days delay and there is a 505 days delay after the dismissal of the review, a 505 day. And your lordships have said that as far as a curative petition is concerned, it cannot be filed as and when a party considers it. So, sorry. So this really ought to be closed. I'm sorry.
I'm only saying you will argue this somewhere else. That's all I'm again. So we understood your point. Why take it up here?
That's really up to the court to hold as to whether there is a means and ends. There is something in the means and ends submission.
We have understood your means and this thing. Point.
Yeah.
You feel no, there is a procedure which must be followed. We felt that it has a very large ramification. We should not wait for a particular case to arise, then to be referred to 3 judges, then to be referred to 5 judges. That is why Chief Justice placed it. We have heard not the parties alone, we have heard everybody. So this is not something which is a list being decided and to see the parties in that sense. And therefore, at the threshold, we kept it. So, to the extent you feel don't do it in this manner, we have understood it.
Yes. Ought not, well, I said, I'm not saying don't do it. I'm saying we ought not to do it. I mean, who am I to say don't do it?
On the lighter side, we've done it.
Means the same thing.
Perhaps ought not to do it. That's how I'll put it.
We've done it now because in this manner, we feel we have to
Very
close.
well. Anyway, your lordships have now followed the point. So I now move on to my next point. Now, your lordships have the Arbitration Act with you, or should we go to the sections which are mentioned here? Okay, let me just indicate to your lordship. I'll take you to the act as it appears from the record. I've now kept that whole issue aside. Now, my lord, sorry.
I understand you correctly that as a proposition of law, you want to canvass that the issue of a stamping of an agreement should be looked at in 11.6 itself. Is that the proposition you are advancing?
Yes.
So
yes. So, Manoj, let me simplify.
You are in different jurisdiction.
Okay. So let me now, Manoj, let me simplify. Let me give you my understanding of the law. If we take up the Arbitration Act or whatever electronic copy your lordships are referring to, there are 3 situations which arise. So I'll give you my conclusion on all 3. The first situation which arises is the law as it stands today. If we pick up the Arbitration Act, I'm only on 11.4 at the moment. You could have a Supreme Court / High Court appointment, depending on international or domestic. That is situation 1. Situation 2, as 11.4 stands today, it could be through an institution which is designated or appointed for the purposes. That's the second situation. So 11.4 as it is applicable post 2015 Act today. The third aspect, the third dimension is what Mr. Khambata mentioned briefly, which is that, look, we now have a 2019 statute which has not been brought into force, which sends the matter, Justice Khanna also mentioned it, which sends the matter into the realm of an institution, correct? So first, let me clear my position. If it is to go, 11.4 is to go directly to an institution, in my understanding of the law, there is no impediment in terms of stamp duty. So the moment the 29, and that's in fact one of the reasons why I'm going to request the court, please do not exercise such jurisdiction as you are choosing to exercise. Because there is already a statute. The statute refers parties straight off to the 2019, under the 2019 amendment to an institution. It does not require any interference or any intervention by a court or any application of mind on the part of the court. That body will not be a body which is entitled either by the consent of the parties or under law to receive evidence, and therefore the stamp duty question will completely pale into insignificance. So that's one situation. So it will not apply. So this problem won't arise. All that is needed is the 2019 Act is brought into force, the relevant provisions, and the problem disappears. That's one. So this has, of course, multiple dimensions to it, including whether your lordship should even at all exercise jurisdiction. You'll keep that at the back of your mind. Now we come to the second situation. The second situation is, your lordship may just go to section 11 for a moment. Just have a look at section 11. As it stands today, you will find it at page 1210 of volume 4A. Your lordships have it? Yeah. So, well, I'm now reading 11, appointment of arbitrators. We are on page 1210. Appointment of arbitrators. A person of any nationality may be an arbitrator unless otherwise agreed to by the parties. Now, subsection 4. If the appointment procedure in subsection 3 applies and a party fails to appoint an arbitrator within 30 days from receipt of the request to do so from the other party, or the two appointed arbitrators fail to agree on a third arbitrator within 30 days from the date of appointment, the appointment shall be made upon request of a party by the Supreme Court, or as the case may be, the High Court, or any person or institution designated by such court. So again, I'm just indicating to the court our position. If under the law, now 2019 Act, I've said, that is not brought into force. Even under the law as it stands today, there are two situations. One, which is the one which commonly prevails, which is that the High Courts and the Supreme Court continue to appoint. But there is also an expression, or any person or institution designated by such court. Now, when this went before the High Power Committee, or what Mr. Kambata referred to as the Sri Krishna Committee, they looked at the provision as amended by the 2015 Act, and they, following on the earlier Law Commission report, were both of the view that even this provision as it stands today does require the court to send it to. So there will be some application of mind on the court. So therefore, they have introduced, they've recommended the suggestion, they've recommended in terms of what is to happen moving forward. And the recommendation is, once the 2019 Act comes into place, there won't be any reference to that. So I thought I should place this before you.
If one looks at the provision as it applies today, in fact, none of the High Courts or the Supreme Court has done it. But if we had passed, the High Court or the Supreme Court had passed a resolution and designated authority or an institution, all 11 applications would go to that institution. Under the law existing as of now,
yes,
once the High Court or the Supreme Court authorizes the institution, then that institution will appoint an arbitrator in 11-4. All of them. We have not done it. That's a different matter. That's a different matter.
No, but may I just, Miller, that is a possible, that's a possible view for your lordships to take. So then the situation is that you have a situation where moving forward post 2019 Act, there'll be no question of such a problem at all. And secondly, if the prima facie view which was expressed by your lordship just now a moment ago is that if there is a designation by a High Court, then that's another way in which the entire problem may go. But I thought I should just mention to you that the Sri Krishna Committee, when it made its recommendations, read this very provision differently, leaning on the earlier Law Commission report, which also took the view that even as the post-2015 Amendment Act, there is still an aspect which is left for the court. But that's really, that's controlling. Your lordships are left to decide that aspect.
As it's in law stands today.
So look at it only as it stands today.
What may happen tomorrow, one doesn't know.
Yes, but I thought
Comes into being,
you're right.
They seem to be having another law, what form it comes.
Correct.
Today conjecture on it.
Correct. So just, sorry. So focusing on the law as it stands today, we have two situations, not the third situation as I mentioned, either High Court or Supreme Court or High Court, and or institution designated by the Supreme Court or High Court. My personal view is that if it becomes, once there is a designation and if there is the rules, etc., provide that you go directly to that particular institution, then that institution doesn't have the power to receive evidence, or it's not by consent of the parties that that institution has been given authority to produce evidence, etc. So in a situation such as that, again, the problem will disappear.
But to come back to point out, that was your para 4.7 of your.
Yeah, so so quite right. So we accept that position. So the problem is actually being contemplated. I mean, there is a solution within which is contemplated.
When the High Court or the Supreme Court, as the case may be, are exercising their power under 11.
Yes, so that's the one which we are just now looking at, correct? So now have a look at Section 7, please. So there are 2, 3 elements of the Arbitration Act. Then I'll go to the stamp act. Just as I might just mention, I'm just digressing from here. In my case, and your lordships, I had mentioned it on the last occasion that the parties I'm representing, one person is 90, the other person is 89, and it's rather difficult to explain to them why we're here. But I should mention, there is a decree.
Still, on a lighter vein, there may be still a case for the award of costs to your client payable by the petitioners.
Yeah. So, I just want to mention, there is a decree in my case. So I had filed a suit in 2010 in my case. I had filed a suit in 2010. The suit got decreed after a written statement was filed. So they never objected under Section 8. My suit got decreed. And therefore, I don't know whether Justice Gawai, Justice Suryakant recall, because it's a long time ago that they passed that order. So apart from the stamp duty case and stamp duty issue in my case, they examined the case on merits. And they say now on merits also, we don't think there is any question of arbitration. So the question I ask myself, where is the question of overturning that decision in that curative jurisdiction at all, when the court has decided on two footings, law as well as this. But anyway, now let me come back here.
The court, for arriving at a conclusion, whether under Section 11(6), stamping is something to be done.
No, we'll get into that. Right.
So we will actually not go beyond it. Whether they have argued, you argue, it will not go beyond that.
Correct. So now, I just want to emphasize a few elements as far as Section 7 is concerned. Just 2, 3 parts, and then I'll take you to 16, and I'll read 5 as well at this stage. So just see 7, because there's something which we wish to emphasize. In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. 2, an arbitration agreement may be in the form of an arbitration clause in any contract or in the form of a separate agreement. And 3, the arbitration agreement shall be in writing. Now, I will take you to the definition of instrument, which I think your lordships have realized that we are relying on the Indian Stamp Act, not because it may apply to individual cases, but it's the same thing which is borrowed across the state. Paramateria, we've emailed a set of comparative provisions. It's all in paramateria. So the point here I'm making is it has to be in writing. I don't think there is any dispute with regard to that. It's required by law to be in writing. That's number 1. And in our understanding of the law, if it is required to be in writing, when I take your lordships to the provisions of the Stamp Act, you will find that it answers the description of an instrument. So that's all at this stage. Now, since we are on this page, which I believe is page 1207 of volume 4A, please just have a look at Section 5 as well, since we are on this. Yes, sorry.
4 also. Why don't you have a look at subsection 4 also?
Yes, of course, I'll read it.
Mr.
4.
Dewan, just 1 minute.
Yes, of course.
Just 1 minute.
Yeah.
If we turn to clause C, subsection 4.
Yes.
To section 7.
Yes.
Exchange of statements of claim and defense in which existence of an agreement is alleged by one party and not denied by the other. Let's suppose there's a parent arbitration, underlying contract, unstamped, whatever it is. But a statement of claim is exchanged and defense is also exchanged. Both the parties agree to an arbitration agreement. You need not therefore rely upon the parent clause.
It may
the
be.
clause in the.
Of course, but
parent-
that won't be at
So,
a section
and
11
the
stage.
fact-
May
the
not be at a
fact-
section 11 stage.
Just one.
Yeah.
The fact that the parent agreement is understamped or non-stamped is immaterial then.
Sorry?
In that case, for going into the question of existence of
Maybe.
an arbitration.
You're right, you're right. There's a deeming fiction here. So let me, now I'll read the whole of 4. I'm grateful. This 4 is very important. So please have a look at it. And I'm on section 7, subsection 4. An arbitration agreement is in writing if it is contained in a document signed by the parties, B, so this, I believe, would answer the description of an instrument straight away.
Correct. You're right.
B, an exchange of letters, telex, telegrams, or other means of telecommunication, including communication through electronic means, which provide a record of the agreement. Or C, an exchange of statement of claim and defense, in which the existence of the agreement is alleged by one party and not denied by the other. So, Manoj, just coming straight away to clause 3.
Exchange of emails.
Sorry?
Exchange of emails may also constitute an arbitration agreement.
It may. So, okay, so now I'm just getting a little ahead of the script, but just let me tell you what, where we are, the suggestion which we are going to make. There is because I think your Lordship is also looking at it from a practical point of view. I mean, what happens in a situation. So let me just depart from this section and just provide, supply what we consider is an appropriate cause. Before our understanding of the scheme under the Stamp Act is on execution or before execution, stamp duty is payable. That's the first point. However, apart from that situation, supposing the contract is being worked, there are no disputes. There are no disputes at all between the parties. The contract is being worked. A party can all, and the parties did not pay the stamp duty at the time of execution or before execution as required by law. They can always go under section 31 is our understanding and have it adjudicated by the collector. So that's the second clear method by which you can solve that problem before disputes, etc. arise. The third issue is before you issue a notice, because presumably of arbitration, I mean, the sorts of cases my learned friends are on, Singapore Arbitration Center, Hyderabad International Arbitration, those kind of cases. Ordinarily, you'd go to a lawyer. You would ordinarily require a notice to be sent. You are preparing a section 11. Ordinarily, there will be some individual cases who prefer to do it all by themselves. That is the stage at which you could conveniently, if you find that the agreement, whether the composite agreement or the arbitration separate agreement hasn't been stamped, get it adjudicated. The moment it is before adjudication, no court or either the High Court or the Supreme Court under exercising powers under Section 11 is going to stop or block, because your point will be, I am a compliant citizen. Maybe at the stage of Section 11, before issuing the notice and before approaching the court, I have approached the appropriate revenue authority. This is what I think is the amount. I have gone there. Please appoint an arbitrator. And the court would not, in a situation such as that, say, oh, I can't look at the document, it can't be seen. It is pending adjudication. The court can also, and I'm going to show you also, because after NN Global, 5 judges, both the Bombay High Court as well as and earlier, the Delhi High Court have rendered a judgment which have given a scheme following NN Global, which is time-bound. But I am just now not without any intervention of the court. What is the correct procedure to be followed, which is fair, equitable, and doesn't do injustice either to the parties or the statute? Because what the submission over here was that Section 5 is wide enough. I'm going to take you to Section 5. Is wide enough to override everything. I don't even think that's constitutionally permissible, but I'll come to that separately. So the answer to the question is what happens at a practical level. This is what happens. First stage, before you execute or at the time of execution. Second point, shortly before you move a court or before you issue a notice of arbitration, at that stage you can go and approach. And the third point, which your lordships can clarify very simply, is that in a situation such as this, where a party has indeed approached the collector, there is no question of holding up Section 11 at all, because the party is complying with the mandate of the Stamp Act, and therefore please proceed ahead and go ahead and appoint the arbitrator if you are satisfied that that's a much better, balanced, revenue compliant, statute compliant, and consistent with our court's line of reasoning over a decade, which would meet the ends of justice. So to answer your lordship's question, as far as 4B, you're right. and exchange of letters, telex, telegrams, and other means of telecommunication, including communication, which provide a record of the agreement. So you could have two types of agreement. You could have either just the arbitration agreement through this exchange, or you could have what I will call the larger agreement, of which the arbitration agreement is but a clause. In both situations, before you initiate the process and approach a court, if you find that this requires stamping, you take advice, you submit it to adjudication, and that's the end of it. You've cleared the whole hurdle. There's nothing further which is required to be done at all. We'll come to that. Sorry, I'm sorry. Yes, certainly.
Somebody feels the
agreement
is properly stamped. Let us say. Another person says the agreement is deficiently stamped.
Yeah.
The moment this is done, you are wanting them to move to the collector of stamps to get this adjudicated first, whether it's deficiently stamped or not. If they move 11.6, the concerned arbitrator will decide whether it is deficiently stamped, it is properly stamped.
Yeah, so I'll come to that. If it's permissible in law, of course, that's one.
So
Well, you see,
why should the whole issue is in 11.6, what can be done by the arbitrator? Detain the court in 11.6. This is the only issue which is there.
I agree with you, but Manoj, there is, I mean, your lordships have seen, there is a long line of judgments, and there is good, I will, of course, try and develop and I'll answer. I'm alive to that issue which is troubling. In terms of, your lordship wants our assistance on what is the appropriate statutory design today, not what is desirable. So there may be some situations which are desirable, why not go here and why not go there? But does it lend itself to a possible interpretation of the type which your lordship is suggesting? That's really the question. Or do we go by the rigor of what we believe is the correct position? So your lordships have now seen 7. Now, since your lordship is just on that very page, just have a look at section 5 now. Please just see this and I'll just state the point quickly. Extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Now, my lords, I would respectfully submit that the purpose and object of this section, as consistently understood, is that you don't allow suits to be filed to block arbitrations, applications which are not contemplated under the Arbitration Act, some other type of action which would delay or prevent or stop the process of arbitration from moving forward. That is the purpose of section 5. The purpose of section 5, as we understand it, is not to override a statute such as, and a mandate of a statute, if we are correct, under, say, the Stamp Act. Let me read it again. Notwithstanding anything contained in any other law for the time being in force in matters governed, no judicial authority shall intervene. What is the meaning of judicial authority intervene? You are invited through some sort of an interlocutory application, through some sort of a suit, through some sort of other action to block an arbitration proceeding. That is the intention of this particular statute. Now I just raise a second issue. Your lordships correctly flagged the question regarding, and Mr. Khambata was also correct, with regard to the, your lordship, just give me a moment. Yes, with regard to the legislative competence of those various entries. So your lordship recalls that there is 91, item 91 of 7th schedule, first list, 63 of 2nd schedule, 7th schedule, I'm sorry, list 2. And arbitration comes in the concurrent list. Now the question which I am posing, because I believe that the interpretation which is being suggested by them, that please use section 5 to trump, so to speak, all these stamp acts, is constitutionally infirm. And I'll just state my point why. Stamp duty, as we have just indicated, falls within the respective legislative realms for the purposes of taxation or finance or raising revenue. We don't believe that in exercise of powers to frame a arbitration law, Parliament can trench upon an act or a power which is left with the state legislatures to impose or an exaction in the form of stamp duty. So section 5, it would be very dangerous. I mean, this is a submission. It would be incorrect. Let me not say dangerous.
For arbitration, That is.
Arbitration is, I think, 13(3), Roman, 7th schedule, list 3. 13.
And arbitration. Yeah.
You're also inside that. Civil procedure, including the manner included in the Code of Civil Procedure at the commencement of the Constitution, limitation and arbitration. So, this is
the purpose of the Arbitration Act is not to prevent the collection of revenue. The question is, what is the stage at which that has to be exercised?
I agree with that.
Forum
I'm just
which will
saying
determine, see, ultimately it's the forum which will determine. Nobody is saying states' revenue is to be jeopardized.
No, that of course. That we'll have to get into the Stamp Act.
In balancing it, you say, okay, let the whole matter proceed to the chosen judge, which is the arbitrator.
Right.
Instead of normally a court would adjudicate it. Now here.
So whether that can be done, not whether it's desirable, but whether under the statute as it remains,
is whether if it is sent to the forum, the forum, which is the chosen forum. That forum will determine whether it's deficiently stamped, unstamped, does it require stamping, etc. Why under 11.6 detain it? Contrary to the whole concept that you choose a judge in arbitration, and therefore the chosen judge will decide which way to go. That's all.
I don't think there's any problem on that at all.
That's the only thing we're saying.
The question, at least the way I would look at it is, as to whether, well, let's see the two issues over here.
Why I put it to you was, they also.
No, first of all, I agree with what your lordship is saying. Namely, I am not disputing that the arbitrator can't do it. I am not for a moment. The question is at an anterior stage. Sorry.
Get to that part. They have argued many issues. At some stage, we have been trying to say that, look, what we are examining is a very limited contour.
Right.
Given there is 11.6, there is a power.
Okay.
That there are some cases where need to be shut out under 11.7.
Right.
As the Chief Justice put it. But stamping is an issue being curable, and it's a defect, but a curable defect. Revenue related. Let the arbitrator determine.
Right. So,
what you're wanting to say.
So correct. So I'll just respond to that straight away. First of all,
Sorry, interrupting.
No.
Because once, are you also accepting the separation between the severability of the arbitration agreement with? Let's assume the contract is found to be void. Let's assume the contract. Section 65
the
of
general contract.
For some reason.
Yes.
Section 65 of the Contract Act applies.
Right.
Then also you have to compensate.
Yeah.
If the arbitration agreement is valid,
right,
the arbitrator will then apply Section 65.
Right.
Of the Contract Act.
Yes, of course. But provided it is appropriate.
Let's assume so.
Right.
Suppose for non-stamping.
No, I accept that. Your lordship is right. I agree. It can be done. But
that answers the question. Why should we stall the arbitration?
Should I just, well, first of all, I accept the position. I don't think anybody is contesting it, that as far as the arbitral tribunal is concerned, the arbitral tribunal has jurisdiction. The issue is, when we are going through a Section 11 route, and the expression which is used by counsel on the other side is, that arbitration agreement, according to us, has to be seen before you appoint under Section 11. Has to be seen. Now, that examination of the arbitration agreement, what is the mandate under the Stamp Act? Does it get in any manner diluted by, when a court looks at it, does it in any manner get diluted by the provisions of the Arbitration Act? And is it a situation where only one forum is to look at it? Or is it a situation where potentially at least you can have, or is the requirement of law is that the court, if it comes up before the court for the first instance, the court ought to look at it. That's the, I understand the point.
You see, being a curable problem, a revenue generating issue, that it has to be looked into, certainly nobody says can't be looked into. Why should under 11.6, which is a very, very minimal intervention, deal with this issue? Why should it not go to an arbitrator? Because
all right, but so I follow. But the question is, what is the law as it stands today? I think your lordship put your today's law. Now just have a look at 16. Please just look at 16. Please look at Section 16, which in terms of the PDF, rather the volumes, you'll find them at 14, capital A, volume 14, 4A, 4A 1214. 1214. Now just look at competence of arbitral tribunal to rule on its jurisdiction. The arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence or validity of the arbitration agreement, and for that purpose, an arbitration clause which forms part of the contract shall be treated as an agreement independent of the other terms of the contract. So this is being used. So as far as severability is concerned, there's no doubt that the arbitration. However, there is a limited fiction. I'm borrowing your lordship's words. The fiction is for the purposes of section 16 determination. It's not as if that for all intents and purposes, this becomes a standout clause, a separate agreement, and if that agreement is stamped, it is to be regarded separately. No, it is only for that, please see the expression, existence or validity of arbitration agreement, and for that purpose, the arbitration clause which forms part of the contract shall be treated as an agreement independent of the other terms of the contract. So I would respectfully submit this is a very limited fiction which is coming in. The language is very, very clear.
11.6 uses the word examine.
11.6, yes.
16
Let us see 11.6.
Ruling.
Yes.
There's a very distinct connotation in law between an examination and a ruling. A ruling implies a binding determination. Examination means a scrutiny. So the power of the court, the first look.
Yes, the first look. Yes,
very beautifully put it in para 126.
Yes.
Is the first look is for examination, a first level scrutiny.
Yes.
It's not rendering a binding determination, because when the legislature has used two distinct words, examination in 11.6 and ruling in 16, ruling means actually a binding or a conclusive finding.
So let's just have a look at section 11.6a. Now we are going back. I've made my point. It's for a very limited purpose that section 16 treats it. So your lordship is going back to to section 11, which is on page 1210. Please have a look at 6a. The Supreme Court, or as the case may be, High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, decree or order of any court, confine to the examination of the existence of an arbitration agreement.
Very limited scope.
Very limited.
We'll come back.
One thing which will cut short judicial time, section 33(2)(b, Stamp Act itself provides for delegation of those duties to an officer. An arbitrator would include that, my lord. That provision may cut short a lot of conflict between the two acts.
Section 35 will have to be.
Yes,
Roughly how long would you take? Because there's another matter. That's why I'm not otherwise to stop you in the ranks or anything. So that we adjust that other matter.
I'll try and wrap up.
Reference to a three-judge
half an hour. I'll take half, but Mr. Nair is
I'll take half an hour, 15, 20 minutes, half an hour, whatever I can get.
Because we restricted it. We restricted, and you are for an intervener.
Yes, that's correct. In fact, like Mr. Kambata. No, look, Mr. Kambata was the CRM of the Hyderabad Center. Look, my proposition is actually going to be based on severability, which, Manoj, in fact, I have a different position compared to what Mr. Kambata has taken, because in my respectful submission, you cannot expand severability.
But at the end of the day, I still come back.
There's a three-judge bench between me, Justice Pardiwala, and Justice Manoj Mishra. It's a difference of two judges on that medical termination of pregnancy. We'll take that up at sharp 2 o'clock, and we'll come back in a combination of 7 the moment that gets. So it should.
All right, very well.
चश्मा ये रखो। I check.
Before my learned senior begins, just one point only. A lot of submissions were made on the fact that this is not a live matter. We haven't addressed your lordships at all on facts because we are before 7. And therefore,
Yes, yes, absolutely.
I don't want your lordships to carry any impression it's not live. We haven't uttered any submissions on facts.
Absolutely. Yes, Mr.
No, it's very much not a live matter, and I'm going to request your lordships.
Whether it
that
is live
these-
or it is dead.
Sorry?
We decided somewhere else, whether it is live or dead.
Sir,
we decided
see,
somewhere else.
we just had the opportunity during lunch to reflect upon this. Because we believe this means and ends issue is something which we will reflect on later. I'm not saying that I'm going to develop it right now. But what is this court doing? What this court is seeking to
You
do
already argued on
is to
that.
provide.
You
No,
already
I'm
sufficiently
on
argued on
another
that.
aspect.
You have started on merits.
Yes, but I'm now deviating and I'm going back to a very important aspect which I want to emphasize because your lordships are saying that you will reflect on it. What I would like your lordships to reflect on is it's essentially providing an intra-court appeal without an appeal. Without an appeal, it's going from 5 to 7 without there being an appeal, without there being a process, without there being a procedure. So it's something to reflect on. I'm not saying no. I'm sorry.
And if an appeal would arise, if we were to reverse the view insofar as your client is concerned, we are.
No, even on law, you see, I was just, anyway, I'll go on now to the stamp act, but I want your lordships to very seriously consider, because if you have in the future, some judgment comes which XYZ doesn't like, the question I ask myself is, can the Chief Justice of India constitute a larger bench and just put it before that bench without having a live list? Or decide whether there's a live list and then do it? I don't believe it can be done, but anyway, that's for your lordships to reflect on. Now, sorry. I'm sorry?
There is a second, there is a second matter which is listed before my.
The section 11.
Section 11 is listed before my lords, and that was placed before 5. Certainly, my lord, the Chief Justice of India in Dawoodi Bora can constitute a bench of the relevant strength. Seka Dobrik is listed before my lord. All this, my lord, may be there in the first matter. There is a second live matter which your lordships have listed.
There's no live matter, at least that I am aware of. There is some live matter there. Then that's the appropriate case. Then I completely agree with the amicus. In that case, an appropriate order can be passed.
I'm sorry, this is becoming a little excessive on this issue.
So it's a very serious issue, my lord. It's a very serious issue.
You are entitled to your view. I'm not saying this. It has been repeated.
No, because it's about the institution. And if this becomes a precedent, it's very, very.
On that. Said we may agree, may not agree with you, but
No, of course.
that goes on.
Yes. So now let us go to the Indian Stamp Act, which is where I want to.
Nothing on both sides have argued. Let's not see what I'm personally finding in all these constitution bench matters. Things go here, there, everywhere. Everybody wants to have a chance. Everybody wants to say something instead of deciding what the issue is before us. That's the problem.
And now we are clear that there is a second matter.
The writer side, because chief is liberal enough to listen to all this, doesn't mean this goes on.
I'm so grateful.
And we have a second matter. We have a second matter which is a section 11 directly before us.
Because, my lord, we were the main.
Have you filed your written submissions? We look at the written submissions, no difficulty.
No, that's all that we are requesting.
Highlight only one point.
No, please.
This is not permitted.
You know, this will not be permitted.
will not
I
be
can
permitted.
assure you that if you argue for another 5 minutes, you'll be washing out.
Within half a minute,
Sir,
complete.
listen to me, sir. You did that in the previous matter also in Sita Soren the other day.
Yeah, sir.
If you argue for another 5 minutes, you will be washing out the impact of the argument of the lawyers who have argued before you. So in your interest, please allow the other side to argue.
May I make a small request? Since I appeared before the Constitution Bench for NN Global, as also before the 3 judges, was led by Mr. Grumman. Would your lordships care to hear me for 5 minutes?
We'll see how much time we have at the end because we have to conclude by 4 o'clock today.
Nothing more than
that. Mr. Khambata appeared for SIAC, I'm appearing for the Hyderabad Center. Look, there are certain institutional points that we want to make.
No, in institutional points, I just wanted to clarify what you will address. Are you saying that the 11.6 must address the issue of limitation first? Is that the institution's view?
No. And the point I want to...
That's the only issue we are deciding.
That's right. No, the only
what
point that
one
I want to
institution may
make-
say, another institution may say is not relevant to mine.
The only point, Manoj, I want to make, in fact, Mr. Khambata sort of hinted on it. And my respectful submission is that your lordship should, in fact, looking at effectively parity, take the view that under section 11, your lordships can't take evidence. If your lordships takes that view, then Manoj, the entire section 33 of the Stamp Act becomes inapplicable. And that's really what I want to make good. That's one point.
So you are really on this side, Mr. Diwan.
Manoj, on the point of 11, in fact, that's what Mr. Khambata pointed out. But on the
Your physical situation, situation.
separability.
He's undercover.
The reason why I am here is because on the doctrine of separability, my respectful submission is going to be that no, they're not separable documents for the purposes of the Stamp Act. And to that extent, the 5 judges are correct because you can't expand the doctrine of separability beyond section 16. And that's the other point which I've made. Good. I don't need more than 2 minutes. 10 minutes on these. That's it. Because Mr. Khambata has addressed your lordship suggesting because what Mr. Khambata has suggested is that expand the doctrine of separability. My respectful submission is...
We are not going to that issue. I just don't
but that's the
understand.
basis. No,
We don't understand. The issue is narrowed down.
Correct. But why are you
After narrowing of issues, still everybody wants to address on everything on this earth which is possible to be said under the earth.
There is the entire genesis of NN Global 1 was the doctrine of separability, suggesting that because of the doctrine of separability, the document didn't have to be stamped. NN Global 2 goes and says, no, it is not separable. They are all part of the same agreement. The argument made by the other side is expand the doctrine of separability. That is going to be inconsistent with our act. It's going to be inconsistent with the entire line of English law decisions which we've continued to follow, which have clearly said that it is separable only for the perspective of invalidity, not from the perspective of every other matter. It is still a part of the bundle.
But it's not necessary for us to see what are the outer limits of the doctrine of separability here at all. We have to only decide as to whether at the stage of section 11(6)(a), The court is required to examine whether the instrument has been insufficiently
And
stamped.
on that point, my respectful submission is the way out of this conundrum is by taking the view that your lordships cannot receive evidence under section 11. Because your lordships is not a court under 21E. If you're not a court under 21E, because the appointment goes either.
All right, yes, Mr. Diwan, let's hear.
That's
Yeah,
the
Mr.
limit
Diwan,
of
yes.
submission that I will make.
So, Manoj, very quickly, may I just take you, please, directly to page 329 of volume 4A. So now I'm on the Stamp Act. So I'll just make a few comments and a few provisions. So first, your lordships may go to page 329 of volume 4A, where you will find the definition in 212 of executed and execution. Executed and execution used with reference to instruments mean signed and signature and includes attribution of electronic records within the meaning of section 11 of the Information Technology Act. Then just please read a little further, 214. Instrument includes every document by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. B, a document, electronic or otherwise, created for a transaction in a stock exchange or depository by which any right or liability is or purports to be created, transferred, limited, extended, extinguished, or recorded. So, Manoj, I want to now just tie up these two definitions with the definition under Section 7 of the Arbitration Act. Arbitration Act is required to be in writing, where I think that's common ground. Please link that to the definition of the word instrument. I believe there is no escape from the fact that the arbitration agreement is an instrument broadly covered by this definition. Now, please move on. Section 3, your lordship knows, is the charging section, so I'm not taking you to that. Please go directly to Section 17. Section 17, which you will find at page 348, same volume, 348. Now, this is the point which we alluded to in the morning. Instruments executed in India. All instruments chargeable with duty and executed by any person in India shall be stamped before or at the time of execution. Now, this is the clear mandate of the law. So, Manoj, I recall Mr. Datar was mentioning that he had his client in the old Madras City Civil Court days who used to only stamp 50% of the documents. All right, you run the risk, but the law mandates that you must execute at the time or before. Before or at the time of execution, you ought to pay the stamp duty. So this is something which the court will keep in mind. That's the time when you do it, but that's not all. So Section 18 is for instruments other than bills, notes executed out of India. So with your permission, I'm going to skip that. Please now go to Section 31. This is important for my purposes. You will find it at page 355. Now, this is the route which we suggest to the court. This is the correct way out. What happens when a Section 11 application is filed and there is some dispute with regard to it? So I'm suggesting, I'll read Section 11(1) and then I'll just make this short submission. Adjudication as to proper stamp. When any instrument, whether executed or not, and whether previously stamped or not, is brought to a collector, and the person bringing it applies to have the option, to have the opinion of the officer as to the duty, if any, which may be chargeable, and pays a fee, such amount not exceeding ₹5 or not less than so and so, as the collector may in each case direct, the collector shall determine the duty, if any, with which the judgment, the instrument is chargeable, with which in his judgment the instrument is chargeable. So this is in short the route we are suggesting. First, on or before execution. If not on or before execution, shortly before you make a Section 11 application, just as you get your pleading drafted or before you issue a Section 11 notice. I'm sorry.
You are right. This is a provision.
Yeah, this is a provision and this is the correct way. I'm sorry.
Practical terms, if we apply it, it will be chaotic. It will be chaotic, to say the least.
No, but why would it be chaotic? Because that's what the law requires.
You don't know what happens if you apply over there, how much time it takes.
No, so to that therefore I'm making another suggestion.
The type of orders which are passed.
No, so I'm just making a suggestion to the.
Less said the better.
This is no possibly your lordship's experience.
And
is
it's
wide.
not mandatory in law. It's not mandatory in
No,
law
I'm
that
not.
we have to go under 31.
No, so Manoj, may I just say this? As far as this.
Don't make it mandatory by a judgment of this court.
No, I'm saying that first, what is mandatory is at the time of execution or before execution. That's the mandate of
stamp duty part.
Stamp duty part. Second, it's not as if a party is hobbled and has to wait. He or she can, before issuing the notice under Section 11, arbitration notice, or before making an application, he can follow this route. I'm not putting it any higher than that. And your lordships, while molding the relief or issuing directions, may issue appropriate directions that in a case where the matter is pending adjudication, Section 11 can proceed. That's all. Now I go to the next point. Now look at 33. Look at 33. Please look at 33, which your lordship will find at 357. Now, examination and impounding of instruments. Every person having by law or consent of parties authority to receive evidence, and every person in charge of public office, except an officer of police before whom an instrument chargeable in his opinion with duty is produced or comes in the performance of his functions, shall, if it appears to him that such instrument is not duly stamped, impound the same. For that purpose, every person shall examine every instrument so chargeable and so produced or coming before him in order to ascertain whether it is stamped with a stamp of the value of the description required by the law in force in India when such instrument was executed or first executed. So here I make just 2 points. Your lordship said that we can look at marginal notes, at least to judge the drift, etc. of the section. This uses the expression examination, and then the second is impounding. I believe that I have no doubt, following your lordship's judgments, that when a Section 11 court is applying its mind, your lordships have held it's not mechanical. There is a application of judicial mind, and therefore the expression is examination, and this would cover a situation where a court is looking at it under Section 11. This is one aspect. Now, please go. Your lordships will just move on to Section 35. Section 35, which is on page 359. Now, please see this. Here we have there's a slight difference, at least on construction. We see this as 4 distinct points, but Mr. Khambata mentioned that there are 2 buckets. Please see, instrument not duly stamped, inadmissible in evidence, etc. No instrument chargeable with duty shall be admitted in evidence for any purpose by which a person having by law or consent of parties authority to receive evidence, or shall be acted upon, registered, or authenticated by such person or by any public officer unless an instrument is duly stamped. So there are 4. 1, as your lordships correctly said, receiving evidence, admitting in evidence. That's 1. 2nd, acted upon. 3rd, registered. And 4th, authenticated. So there are 4 distinct situations which Section 35 envisages. Admitting in evidence is one of them. Section 11, I would respectfully submit, is not an admission of evidence stage. It's a stage of acting upon. I don't think there can be any, that's our submission. I don't believe there's any doubt, at least in our mind, with regard to the fact that the Section 11 court is required to act upon. Now, if this is the mandate of the law in terms of Section 35, I've already read the embargoes, etc., with regard to the section. Then the scheme of the statute, at least to us, appears to be that before a court under Section 11, if this issue is raised under Section 11, however narrow the jurisdiction, because undoubtedly it's a narrow jurisdiction, this would be within the duty and obligation of the court. Now, my lords, there are 6 characterizations which your lordships have used recently in terms of this. So I'll just mention them. We have put them in our written submission. One is your lordships have said Section 11 is not mechanical. That's one way. The second expression used is your lordships have said it is not ministerial, but it is performing a judicial function. So that's in Vidya Roli as well. The third, your lordship's recent judgment is it's restricted to the eye of the needle. A 4th expression your lordships have used in Vidya Roli and other judgments is to cut the dead wood. The 5th is it's a very narrow jurisdiction on existence and validity, which is the magic eye judgment. And of course, when in doubt, refer. So having regard to the conspectus of these tests, which are really different ways of saying that it's a narrow jurisdiction, nevertheless, according to us, just on a reading of the Stamp Act, and I have made my submissions on Section 5 of the Arbitration Act, there doesn't appear to be any reason or justification to exclude the operation of the Stamp Act at the Section 11 stage. Now, my lords, we are fortified in this, and here I'm just requesting you to please, I'll just request you to turn to, if you would, to volume 2, page 6, please. So volume 2 is my submissions. Volume 2, page 6. Please just go to page 6. It'll just save me a lot of time. Would your lordships have para 1.4? Sorry, Manoj, I'm on page 6. Do you have para 1.4 page? No, I just want to spend, I'll just address the court. Which page? Same thing? Para?
Interplay the
To section 35 will apply because of the and shall or shall be acted upon.
Yes, acted upon. So
acted upon is also qualified by.
Yes. I'll
by
just
any
go there.
such person. Now, any such person means who?
No,
A
that's the
person
registry, correct?
having by law consent of parties authority to receive evidence.
Yes, but yes.
Acted upon is also qualified by any such person. Any
Right.
such person means the person referred to earlier.
Right. No,
Now, there is a
can
word
I-
public
can I-
officer. I mean, I don't know whether
No,
you
but
can
we are a
put
court.
the court is a public officer. Possibly the court is a public officer.
So, Manoj,
Sorry?
No, so this is, I mean, astonishing.
But a section 11 court may possibly be a public officer. Perhaps.
Here I may just draw attention to 33(2)(b). There's an act of delegation which the Stamp Act itself envisages. The High Court can delegate this function of examining and impounding to an officer, which includes an arbitrator. He's authorized to take evidence.
In fact, my submissions deal with this very point, saying that all of this goes to the arbitrator if you read 33, 35, because what parties have done is that by consent, even in terms of the Arbitration Act, by consent, parties have agreed that as far as their disputes are concerned, it is the arbitrator who takes in evidence. That happens because of section 19 of the Arbitration Act. So when you harmonize both the provisions.
The 33(2)(b recognizes this.
May I just make my, sorry. So I'll just summarize it, how we understand it. We believe, if we are correct, that if it's going to an institution of any sort, this embargo under section 35 won't apply under the scheme under which it presently applies. That's our understanding.
Yes.
That's one. Equally, we have no doubt that if it is the High Court or the Supreme Court, then it would be covered and under section 35, and it would be covered not in the sense of taking evidence, because your lordship may not be at that time admitting it to evidence, but certainly it is to be acted upon. That's why we sought to link acted upon with your other judicial responsibility, judicial application of mind to satisfy yourself on existence, however confined that jurisdiction may be. That's the short and submission. So we believe 35 does apply to a section 11 court, and it does apply to the High Court or the Supreme Court, as the case may be. That's where we are, and the language is wide enough. Otherwise, it might be rendering this ocious. So that's it. So Manoj, I was now on, if your lordship recalls, volume 2, page 6, please. Page 6. May I state the point?
Yes.
Yes. So we are on para 1.4. I'm drawing attention to 1.4 because of the constraint of time. What I want to just mention is that, look, we've had not just one stray judgment, In fact, to one judgment, Justice Gavai and Justice Suryakant are a party. That's the present judgment. We've had a series of judgments which we have encapsulated in paragraph 14. There's a total of about 12 of our judges who've looked at this over the years from 2011 onwards. And the narrowest SMS was, which is the 2011. That Justice, I think Ravindran and Justice Patak, they looked at it from the Stamp Act point of view. And they said that, look, this is clear to us. And therefore, having regard to that, and they placed it on that. Thereafter, just have a look now, I'll read 1.4. It is submitted at this Honorable Court in SMST, so that's the first one. Then we've got Naina Thakkar versus Annapurna Builders. Well, that's also two learned judges. Black Pearl Hotels versus Planet M Retail Limited. That is three learned judges. That, your Lordship has that? 1.4. I'm on para 1.4, page 6, your Lordships have it. So I'm just, to save time, just reading this. So we have SMST, that's the leading judgment, I mean, in point of time. Then we have Naina Thakkar versus Annapurna, which your Lordship may note is two learned judges. Then we have Black Pearl Hotels versus Planet M Retail. That, I believe, is three learned judges. Then the judgment referred to Garware Wall, Justice Nariman and Justice Vineet Saran's judgment. Garware Wall is mentioned. And the present impugned judgment, which was also by three learned judges. So it's what the suggestion which we are making is that what has come about in the five-judge bench. I mean, I'm not saying that there was a reference to the five-judge bench judgment. There is a concern there. But when you have a long line of judgments spanning more than a decade in a situation such as this, on an issue such as this, I believe it is an eminently possible interpretation. The question before the court also is as to whether, because when there is in a commercial field a long-standing set of precedents and understanding of our court, we don't believe it ought to be lightly upset. Not that I'm suggesting that your Lordship is not, going to consider this very fully, but I'm just suggesting to the court that please do not upset this, because we've given you a way out. The way out is not to give a premium on dishonesty of some person who decides for 50%, I am going to pay stamp duty for only half my cases and I'll take a chance. That's hardly the situation. The law requires you to pay stamp duty, pay it. If you don't pay it, the law gives you another chance before you approach section 11. And if not, now I come to the if not, what is to happen? Now here, just please go to page 36, same written submissions, please. 36, please. Now here, now just have a look at two judgments referred to here, and Mr. Nair will expand on this. Your Lordships have para 4.5. 4.5, your Lordships have. So I'll just sum it up. So after our five-judge bench judgment in NN Global, both the Delhi High Court as well as the Bombay High Court had occasion to examine how are we going to do this. So there are two judgments, Splendor Land Base, and there is a further one called, I think, John Cockerill. Yes, that's mentioned in 4.6, correct? And they have given a streamlined process. So I am commending that with whatever further suggestions which your Lordships may feel appropriate for the purposes of how to move forward, sustaining NN Global. So this is another point which I thought we'll make. This wraps up the correct scheme. Now I want to make one further final set of submissions with regard to the Contract Act. Now I want to, may I just make that submission very quickly? Now please just take up the Contract Act. Yes, and your Lordship will find that at page 280 of volume 4A. Volume 4A.
Which provision are you referring to, Mr.?
Sorry?
Which provision are you referring to, Mr. Devan?
No, much was made of those definition clauses, etc. Now, I just want to point out what is the Contract Act saying, and the whole thing is void, etc. That's not the case at all. And since we're straying, I'm meeting this because much time was spent on these particular definitions and on how the Constitution bench has done it and how Justice Nariman in Garware dealt with it. So I want to just explain it. The standard, the original template which was used by our court was founded on SMS Steel, which your Lordship sees Stamp Act. Thereafter, the bench felt in Garware that there may be another perspective. Now, what is that perspective? Let me just place it. So your Lordship has now page 280. So just now see the interpretation clause, section 2, please. On that page. In this act, so first of all, it's in an interpretation clause. Then it says, in this act, the following words and expressions are used in the following senses unless a contrary intention appears from the context. Now, please go on to what was emphasized, G, 2G. Now, let's see what this, first let's read it, and then the context, and then see whether it has any reason to deviate from the 5-judge bench. G, an agreement non-enforceable by law is said to be void. Is said to be void. It's not it is void. It is said to be void for the purposes of this act. Now see the next one. An agreement enforceable by law is a contract. And then please see J. A contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So, the ambit of the expression in section 2 of the Contract Act is enforceability and relative to enforceability, whether an agreement is void or not. That is how this is to be understood. It's not to be understood, oh, the whole agreement is void, nothing can be done. That's absolutely a wrong way of looking at it. What the court is saying in Garware, etc., is that once you remove this taint, or you remove the shadow, as your lordship said, or the cloud, as your lordship said, then it becomes fully enforceable. So for all intents and purposes, your contract, upon being appropriately stamped, becomes enforceable. There is no peril to commerce, as is being suggested, that the whole entire, the country and commerce is going to come to a grinding halt if this judgment is allowed to sustain. A line of judgments which has held the field since 2011. So my respectful submission is, there is no justification on, and when your lordship recalls, for example, commonly, what do we understand? That if there is a fraud, for example, everything is void because fraud vitiates everything. But that's not how the Contract Act looks at it. The Contract Act says that if there is a fraud, it is voidable at the interest of the counterparty who was induced. So for the purposes of the Contract Act, what is void, what is voidable is much more nuanced than what is being suggested by the other side, and it ought to be understood in this restricted context. I'm very grateful. Thank you.
Thank you, Mr. Devan. Yes, Mr. Nair.
Very briefly, my lord, because most of it has been covered. My lord, the aspect that really, my lords, what we have heard my learned friends argue, my lords, nobody has, to my mind, contested the fact that section 35 has to be given play. That is not in dispute. I don't think anybody has contended that section 35 has no role whatsoever in an arbitration or in a contract. The only question is, at what stage will it trigger? Will it trigger at an 11th stage? Or do we, my lords, if I can call it that, if I can call their argument the kick the can argument, my lord, that should be send it down to the arbitrator and then that the arbitrator or the arbitral tribunal deal with it. Now, my lord, the 11.6a point, my lords, as primarily Mr. Datar contended, my lords, was based on 3 facets. Because 6a, my lords, can be construed 2 ways. One is either what is the width of the jurisdiction that is intrinsic in 6a, or an efficacy argument, that it is not efficacious at this stage, we are delaying arbitration, that is not in the interest of ADR, etc. So let us send it down back to the arbitrator because anyway 16 has some kind of mechanism. I'll focus first, my lords, on the 6a part. 3 aspects, my lords, that were highlighted in 6a. One, my lords, was the use of the word confine. It says confined to the existence of. The second part was existence, and some, my lords, emphasis was laid, my lords, on the non-obstante clause, saying, my lords, that because of that non-obstante clause, we should now, my lords, construe it to mean that other statutes or, my lords, earlier judgments have now kind of been diluted. Lords, for each one, my lords, I'll just give few references, my lords. As far as the width of 6a is concerned, post 6a, in fact, most interestingly, in our case, I don't want to get into the merits of that curative, etc. Actually, 6a does not arise. Mine is an 11.6 case. because the notice came earlier, etc., etc.
Before the other bench.
Yes. But in 6A, my lord, your lordships have consistently held that existence means validity as well. Consistently. I'll just give those references, my lord. I don't want to read them. Garware, my lord, which is at page 33 of volume 5A, para 29. In Drolia, my lords, which is page 73, volume 5A, para 153 and 154.4. And, my lords, NTPC versus SPML, that is page 1806 in volume 5A, at para 25, my lord, where, my lords, this eye of the needle test has been propounded, and, my lords, specifically held that the primary inquiry is about existence and validity. So, my lords, as far as that aspect of 6A is concerned, my submission is that validity is a, my lords, legitimate exercise under 6A, because Mr. Banerjee suggested, my lords, reading various authorities and the UNCITRAL, my lord, model, that perhaps it has to be a very restricted and narrow, my lords, approach to 6A, virtually, my lords, taking us back to pre-SBP and Konkan, etc. But, my lords, that has not been, my lords, to our understanding, the interpretation given by your lordships, my lords, even after 6A. Existence includes, my lords, validity. Secondly, my lords, as far as the notwithstanding argument is concerned, lords, the most detailed, my lords, in fact, there's a reference in Duro Felguero, my lord, that the amendment in 2015, because the 6A comes in 2015, that it was intended only to overcome SBP and Bogara polyfabs. SMS was known to the legislature at that point. If the intention had been, my lord, to whittle down the scope of 6A and take out this dispute of stamp, my lord, there would have been appropriate language used. And, my lords, in Garware, my lord, because that contains the most detailed, my lord, discussion as to the legislative history of 6A, including referring to the Law Commission report, etc. Lordship may just note, my lords, paras 12 to 14, 19 and 22. And it is clear, my lord, that the legislative history was such that it only intended to take care, my lords, perhaps the legislature felt that as a result of SBP and Bogara polyfabs, that too many issues were being gone into at the stage of 11 to restrict the scope. But, my lords, in my submission, my lord, that restricted scope does not take away, my lord, the fact that you can get into validity and therefore consequently this issue of stamping, which I separately deal with. Lord, there's one thing I want to show, my lords, why the word examine, my lords, will or could, my lord, encompass the examination on the question of stamp. Kindly just have SMS, one paragraph in SMS, my lord. That is in volume 5A, page 8, at para 22.1.
Para?
22.1. The conclusion starts at 22. I just want to read 22.1. I'm sorry, it's page 16 of the running page, my lord.
Talking about volume 5A.
Yes, volume 5A, my lord. It's the second tab.
Page 16, not page 8.
At page 16, para 22.1. Starting at 22, my lord. May I read?
Yes.
We may therefore sum up the procedure to be adopted where the arbitration clause is contained in an agreement which is not registered, but compulsorily registerable and which is not duly stamped. The court could, before admitting any document into evidence or acting upon such document, examine, please note the word, my lords, examine whether the instrument document is duly stamped and whether it is an instrument which is compulsorily registerable. Now, my lords, the word examine, your lordship will find in 33(2) of the Stamp Act. That is the extent of the duty, my lord.
33 point?
33 subclause 2. The word used there is examine. Well, after the impounding, I'm sorry.
And one also says the court should, before admitting in a document in evidence.
Or acting upon.
Yes.
Yes.
Put it together.
Correct.
So here there's difficulty, one difficulty, we accept this proposition.
Yes.
If we accept that the arbitration agreement is severable, now even if the parent contract or the underlying contract is held to be bad, is to be impounded, section 65 and 70, both restitution as quantum merit will apply.
Yes.
Cannot then it be argued that this issue can be gone into by the arbitrator as by a civil court?
Lord, the question, the severability, Lord, Mr. Diwan has a more elaborate argument on that. But
so quantum merits are decided by the arbitrator.
They can certainly decide, but the question, Lord, the question is this. Lord, the question is this: the argument of severability, does it extend beyond the purpose in 16(1)(b)? Yes. Because our submission is not the purpose of the argument of severability is limited to that. It does not preclude, my lord. Yes. Why not? Of course they can, my lord. But the question is the court precluded under 11? Yes. No, not 35. Kindly see what is the language of 35. 35 first is mandatory. It says shall. There is no option there, really speaking. It shall and shall not act upon. Both. Now, lords, at that stage, my lord, I don't. I'm sorry, my lord. No, but since your lordship mentioned about. No, the point I was trying to make is, I'm sorry. No, my lordship, sir. Now, Lord, 33, the point I was trying to make, my lord, this, the word used in SMS was examine. They were conscious, my lords, while making the amendment. The word used in 22(1), para 22(1) is examine. The language in the Stamp Act is examine. The language in 6A is examine. It is not, my lords, that there is any greater degree of inquiry that is required. So examine, my lords, will encompass. An examination is to whether a document or an agreement is properly stamped or not. Sorry.
Yes.
No, just three short points, my lord. Lord, the second aspect on section 5, my lord. Section 5, my lords, is not a bar. Because section 5 only says, my lords, notwithstanding under as per this part.
That Mr. Diwan made a point. He said
Yes.
the object of 5 was to prevent suits being filed.
Correct, my lord.
To delay arbitration.
But once there is
Once
there is a jurisdiction under 11 9 or my lords 34 or 37, the width of that jurisdiction is not controlled by 5. Just one judgment, my lords, your lordships may note it. I'll not, my lords, I don't have the time to read it, my lords. That's Chingtel's, my lord. It's in volume 5B, my lord. At page 547, sorry, 522. At, my lords, paras 38 and 39. At 547. That 5, my lords, will not control the actual width of the jurisdiction. Please.
I'm sure a lot of other states have this. Under the revenue law, in Maharashtra, if a certain point arose before a civil court, you had to refer it to the revenue authorities for determination. What used to happen then is the moment you got the revenue authorities, everything then went into a series of procedural remedies, a revision, a statement of case, an appeal. So what the experience was that the entire process before the civil courts was stalled because until a finding was reached by a revenue authority, and exactly that's what's going to happen here. The moment we read the stamp act provision to the 11.6a stage, the 11.6 stage, the net consequence is going to be that the entire gamut of remedies under the Stamp Act will have to be exhausted, and that never comes to an end. It goes on for years.
There I have two submissions, my lord. One is, my lord, there is an assumption implicit in this that the arbitral tribunal will handle it better. And that the arbitral tribunal will be able to control the stamp proceedings equally well. That's an assumption, I would say, with respect, my lord, because if the court is not able to control it, my lords, as your lordships are observing, lord, I don't.
The court control it. It's not.
No, it's not controlling. That I'll deal with separately.
Less controls it more. To the intent of an arbitration act, very basic summary nature of proceeding 11.6. Why
Yes.
is it detained at the threshold?
And actually,
whether they control it better, not control it better, the arbitrator to say.
No, if the concern is
the 2019 amendment, though not enforced,
yes,
gives us an idea about the mind of the legislature.
Correct.
Which is to continuously constrict or confine the intervention of the court at the first look stage.
Yes.
By taking it away completely if the amendment were to be enforced.
Yes, my lords. Therefore, my lords, what we had suggested, my lords, kindly just have that the order of the judgment of the Delhi High Court in splendor, because my lord, it sets out a whole scheme as
that
to
you made a point.
As to my lords how to control this.
Delhi and Bombay.
Based with this constitution made judgment,
they have to implement it.
Whether everything should be left in a limbo or they devised a method which you are right.
Actually, my lord, it's not a case of limbo because they've actually devised a method to expedite it and control time frames. In fact, in the Bombay case, they found that the difference was 44 rupees.
But they were implementing the constitution bench.
It's a workable solution is what I'm saying. What I'm suggesting, my lord, it's a workable solution. It's not a solution that can't work, my lord.
Thank you, Mr. Nair. Thank you very much.
Only one, sorry, one last point was on this, on the question of, Lord, 35, it says for any purpose. In Avinash Kumar Chauhan, your lordships have said, my lord, if it is not stamped, unlike 49 of the Registration Act, it cannot be used even for a collateral purpose. That is, my lord, Avinash Kumar Chauhan is in volume 5B, page 104. At paras 22 to 25, page 110. I'm grateful.
I propose to take no more than 10 minutes. So that my learned friends will also.
What are your submissions, Mr. Diwan?
Was my
Are you now mentally on that side or are you still on this side?
So, Milot, I have always, because I'm appearing for an institution, Milot, my difficulty, Milot, was as far as this, the challenge to the NN Global judgment, Milot, was this. We affirm NN Global, the 5 judges, on the basis that the doctrine of separability is limited and that the arbitration clause, save and except for matters under section 16, is part and parcel of the main contract. So to that extent, Milot, we affirm NN Global too. The little leg, Milot, which stands on that side, which is in fact the practical leg, is that under section 11, an arbitration need not be stalled if an arbitration agreement is inadequately or not stamped at all, or the main contract is not stamped.
The only point we are deciding.
Now, why is the doctrine of separability relevant?
But that is the only point we are deciding.
No, that's correct. In fact, your lordships heard Mr. Khambata at length on the doctrine of separability, where he suggested.
Yeah, I've been saying repeatedly, and I think on behalf of people have gone here, there, in many places.
That's right.
We have repeatedly, I think, at cost of repetition, the Chief Justice, all of us have been repeating what we are deciding. If we've repeated what we are deciding, what's the point of saying, he said this, so I'm saying this, so-and-so said this, so I'm saying this.
Why is the doctrine of separability relevant? I won't take more than a minute, Milot, to explain to my lords. If your lordships holds that today the parent agreement and the arbitration agreement are fused for all purposes, save and except for section 16, then the challenge as far as inadequacy of stamping really goes to the challenge as far as the main agreement is concerned. And where there could be, where the level of stamping, the quantum of stamping becomes a matter of dispute. It's a matter which.
They're not really submitting before us.
Because I'll only tell you, lordships.
The point is, if you are debating it, I agree, you have a right to say.
Right.
But we are not dealing with it. We have said so 20 times we are not.
Saying
the only issue we are dealing with is, should at the stage, and Mr. Diwan addressed it, he felt that no, at 11th stage itself, in the first blush, we should look into it.
Right.
Now there says, no, don't look into it. That's all.
Because I have no difficulty, my written submissions are there. In case your lordships go into the doctrine of separability, my submissions are there that it must be restricted. That's all. Now comes the second point, and the only point that I will then address my notes on, which is in relation to section 11. Section 11, and whether, there should an arbitration be stalled. Now, if your lordships has section 33
are you
of the Stamp Act.
I thought you were on the side of this side.
On their side, I just have
Then there's nothing to add.
No, the only difference, is this. Mr. Datta seemed to suggest that a section 11 court could perhaps take evidence. He said, I'm not arguing that they can't take evidence. Mr. Khambata said, perhaps they cannot take evidence. My position.
Why do we have to go into these?
Because of section 33 of the Stamp Act. And I'll tell your lordships why. If your lordships has section 33 of the Stamp Act, what does 33 set out? Because what 33 sets out is that every person by law or consent of parties, authority to receive evidence. Because that's the starting point. Now, by my respectful submission is this. Once parties have chosen arbitration as a mechanism for resolving disputes, they have by consent under the Arbitration Act authorized the arbitral tribunal to be the body which receives evidence, and that becomes evident from section 19.
Thank you. That's exactly what I said before. You have a chosen judge, you have an arbitrator, the arbitrator will take a call.
And the consent. So therefore, Manoj, as far as the second part of section 33 is concerned, it doesn't arise because by consent you've said the tribunal receives evidence. Now, Manoj, what about the first part? Every person having by law authority to receive evidence. Now that is where, Manoj, your lordships has to consider the Arbitration Act and section 11. There my respectful submission, Manoj, is this. Under section 11, your lordships is only appointing an arbitrator. Your lordships is not the court under 2(1)(e). That's the first point. It was appropriate to what followed from the Honorable the Chief Justice, which is that all you're doing is examining the existence of an arbitration agreement. My respectful submission is that that power is constrained only to examination of the existence. Now, when a party comes to a court under section 11 and says, please don't act on the agreement because it is not inadequately stamped. That's not a dispute which goes to existence. Because the agreement exists. The party accepts that it signed the agreement in writing in terms of Section 7. Because all that Section 7 requires is an agreement in writing which is signed by the parties or perhaps exchanged in other forms. Now, if the agreement exists but cannot be enforced, then under Section 11, the court has no power to go ahead and impound a document or even look into the Stamp Act. And therefore, in my respectful submission, really the way out, and that's really the end of my submission is this. The way out for the court is to say, we are constrained because we are not a court under 21E. The Section 11 court has no power to receive evidence. If it doesn't receive evidence, it looks to see whether there's an arbitration agreement in existence. If it is, it refers the matter to arbitration. Because the defense is not that there is an inexistent agreement. The defense is not that I've not signed the agreement.
You are therefore supporting that submission.
To that extent, Manoj, I support that position. Manoj, that's the long and short of what I have. Manoj, all of this has been set out in my written submissions, Manoj. I don't need to address it.
I'm on 707.1.
No, 1 second. Mr. Khambata, how do you read that one part of Section 35? Just a couple of questions really, which one, what is the object of Section 5? I'll come to that in a moment. Section 35 says of the Stamp Act, no instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law or consent of parties authority to receive evidence, right? Yes. A court under 11 is not that authority. That's fair enough. Now, or shall be acted upon, registered, or authenticated by any such person. Now, any such person means the person referred to earlier, the first part, who is authorized to receive evidence. But now, what follows is, or by any public officer. Now, would a court technically under 11 not be a public officer? Because now see 33 for a moment.
Yes. 33 has slightly different language. Person in charge of a public
office.
But I would, with respect, not say a Section 11 court is a public officer. It's a court under Section 11 for the purpose of Section 11, not a public officer. A public officer is an officer who is of the executive, discharge administrative functions, etc.
Yeah.
Therefore, Section 11 court may not be covered by 33 or 35.
33 and 35 were dealt with by Justice Roy, and this expression acted upon was dealt with by him in about 7 or 8 paragraphs.
What did Justice Roy hold on acted upon?
Well, what he says is, your lordships will see 35 is a consequence of 33. 35 is not a standalone.
Absolutely.
33, my lord, the 33 has 2 parts. 33.1, the operative part is, my lord, I'm not going to the first part, my learned friend has addressed your lordship on that. Shall, if it appears to him that such instrument is not duly stamped. So that is an examination which is wider than the 11.6a examination. So, my lord, the 11.6a court is constricted in its examination as compared to any, assuming, my lord, it's a public officer, it's a case of concentric circles. So
your submission really is that the scope of the inquiry in 11.6 court is much more limited.
And that is why your lordship sees Justice Joseph's judgment, which is summarized in paragraphs 161 to 169. His 2 reasons are, he has to then go to the extent of saying that it does not exist in law. That's the error in the judgment. He did not need to, if that leap was required to bring it within 11.6a. So, my lord, if 33.1 doesn't apply, 33.2 doesn't apply, then, my lord, 35 doesn't apply. Justice Roy has taken a slightly different approach as well, that 36 has to be read. And, my lord, there is a case on limitation where there is a decree. A decree is enforceable even though unstamped. So on that basis, he says a decree is, well, not the word acted upon is not an absolute bar. It's a curable defect. That is how he has got around it. I can mention paragraph.
We'll have a look at it.
No, there is one decision.
So there are various ways of, my lord, getting around 33 and 35. We can put in a note on.
Because there's
that.
one decision of your lord, which in fact defines public, which deals with the word public officer in the context of section 33 read with section 73 of the Stamp Act.
What is the citation?
No, the citation is 2005, 1 SCC 496. It's not on record, but we've just taken this out now. And that, that paragraph 3 looks at a public officer as one who would be somebody under section 73 of the Stamp Act, which says every public officer having in his custody any registers, books, records, papers, documents of proceedings, etc., the inspection of which. So there were a category of public, there's a public officers having in their custody registers, etc., were used by your lordships in this decision to say the term public officer having in his custody as occurring in section 73 can be defined by having regard to the expression public officer.
273.
It appears to be, as it says, the term public officer as occurring in 73 can be defined by having regard to the expression public office as occurring in section 33. And then it says the central legislation, including 73, took care to see how the power to inspect was confined only to documents, etc., etc. That appears, Willows, to be one possibility.
Just a small request.
Thank you very much.
Just one point, at least our position. We believe that the High Court and the Supreme Court is covered by the opening part. Every person having by law or consent of parties authority to receive evidence. We are covered by that. We don't need to really go any
Just one request. Mr. Datar is not here. There's a note we had made. We wanted to just hand it over. This covers our points in rejoinder on 5. This I'm handing over the note.
My lord, we just.
The Lordship may see.
On the interpretation of Hindustan Steel, which is in para 65 and 70 of the Constitution Bench judgment. Because what happened there was, after my lord Stamp duty was paid, then it was that it should not be acted upon. So my lord, that is also analyzed. So therefore, to say that the Hindustan Steel judgment will actually have an impact, my lord, is not correct. Because what actually can be acted upon can only be enforceable.
Thank you.
May I put in a short note on public officer? Just a short one.
In another 2 days.
It says an incorporation of the international law perspective.
We'll have a look at it. Thanks.
That's under Article 2.